Okay, thank you everybody for being patient. I think we figured out a little workaround that can get us going. Chair, we can proceed.
Okay, thank you very much. It is now 2:02 p.m. on Thursday, December 12th, and this is the Board of Variances and Appeals for the County of Maui called to order. And so, Chelsea, if we can begin with roll call.
Thank you, Chair. We will start with Chair Green,
I am here in my office alone.
Vice Chair Lee,
I'm here in my office alone.
Member Shibuya. One moment. People are still joining. Okay, Member Shibuya, we're taking roll call.
This is Charlotte. Do you need me right now?
Yeah.
Yes,
Charlie. Yeah, this is Charlene Shibuya in her cubicle alone.
thank you. Member Takashima,
Here in my home office alone.
Member Harry Heck,
Here at the planning meeting.
Member VL,
Here in my office.
thank you. Member Weiss,
Here on site.
thank you. Member
Pardon,
Wilson,
Here in my apartment.
thank you so much.
Thanks, yeah.
Okay. Thank you, Chelsea. Is Jordan Hart here or someone to read in item number 2 on our communication?
Yes. Hi, Chair. This is Carolyn Cortez.
Hi, Carolyn.
Item B1, review and approval of 2025 BVA meeting schedule.
Okay, I assume everybody has received a copy of the schedule for next year. Does anybody have any comments about this? Okay,
And Chair, we should see if there's public testimony on this. Pretty unlikely, but technically we should.
okay, I was going to take it for the next item, okay?
Well, yeah,
Is there-
for both items, yeah.
Okay. Do we have any public testimony on item number 1? Hearing none. I will close testimony item number 1 and ask board members if anybody have any problems with the schedule for next year. Okay.
I will be out. This is Weiss. I'll be out January.
All thank you. Chelsea, if you could take a note of that, please. Otherwise, can I have a motion to accept the schedule for 2025?
Can I just make one comment? The November 26th is the day before Thanksgiving. I don't know if that's going to be people out, just to bring it up. Doesn't matter to me, but
I think
yeah.
traditionally, since Thanksgiving is on a Thursday, they move it to the day before, but
Oh, okay.
oftentimes it never happens.
And it doesn't matter to me, just some people may go on vacation.
Mhm.
This is Weiss. I make a motion to accept for the record our 2025 schedule for the BVA.
Thank you, David. Do I have a second?
I'll second it.
Okay, thank you, Harry. All in favor or any discussion? All in favor, everybody's hands up. I think it passes unanimously. Okay, thank you. So Carolyn, we can read in number 2, if you would please, and then I think we'll open this also up for public testimony before we get into the weeds, okay?
Yes, Chair. Item B2, petition for declaratory ruling. Hayden and Wendy Ogni petitioning to obtain a deck ruling as to the applicability of ordinance 3494, bill number 60, exhibit C, condition number 8, upon the ability to operate a transit vacation rental at 242 Lahaina Luna Road, Lahaina, Maui, Hawaii.
Thank you, Carolyn. I am going to open this at this time for public testimony. Is there anybody who would like to give public testimony before we proceed with this hearing? Okay, Hearing none, we will close public testimony. And I believe the first order of business that I would like to do today is take up this issue of the petition to intervene that the county has submitted. And so I think before we can go further, we have to decide whether we're going to accept or deny the petition to intervene. Michael, if you can clarify for me, do we
Yeah.
is this just for the board to decide, or do we hear from parties?
I think what you could do is have the parties identify themselves on the petition intervene, and then you can allow the county and the petitioner time for oral argument. Maybe, I don't know how much they would need, but maybe 5 minutes each or something to address the petition to intervene and any opposition to that. And then you can go about asking questions and then deliberating on the issue of intervention. Intervention, again, would determine who are the parties to this petition, whether it's the petitioner only or the petitioner and the planning department. So I think you could have the parties identify themselves for the record. Starting with the county, you could see how much time they would like for oral argument solely on the petition to intervene issue, and then check the same from the applicant, the petitioner, make a decision on how much time you want to give each party, and then complete that, go into questions, and then decision making on the petition to intervene.
Okay, who will be representing the county here? Cannot hear you. You're muted. You're muted. You're muted.
Can you hear me now?
Yes, thank you.
Thank you, Chair. Kenton Work, Deputy Corporation Counsel, on behalf of the Planning Department. I filed the department's petition to intervene.
Okay, Kenton, about how much time would you like to do
Less than 5 minutes.
Okay, and who do I have for the petitioners? Mr. Carroll?
Good afternoon, Chair. This
Pardon?
is Sharon Paris. I'm present in person, and Mike Carroll is online as my co-counsel.
I'm sorry, Sharon,
Last name Paris.
I do not see you here.
I'm in person at the meeting room.
Okay. All right, Sharon. And 5 minutes good enough for you too? 5 or less?
That's fine.
Okay. All right,
And then,
Kenton.
Chair, just to clarify, so is Ms. Paris going to be sort of, is going to be the legal counsel here that's going to be responding to questions and making the arguments in this case? Because I see 2 attorneys, and usually we would have one of them sort of confirm that they're going to be the one participating in the argument. So we don't have like a back and forth between attorneys, just to get that clarified.
Yes, I will be doing the argument. Mike Carroll is online and will be operating our PowerPoint presentation.
Okay, thank you very much. All right, Mr. Work, if you would like to begin discussion on your reason to submit this petition to intervene.
Yes, thank you, Chair. The motion or the response to the request for the petition to intervene was from the Epogni's side, that they will argue that the department doesn't have a right to intervene because this is not a contested case. And while this may not be a contested case in the sense of an appeal of a director's decision or an appeal of a notice of violation, but the Epogni's petition for a declaratory ruling is clearly contesting the department's application of Ordinance 3494 to their particular property. And they're asking the board to make a declaratory ruling in their favor of how they view Ordinance 3494 applying to their property. They're contesting how the department applies this ordinance to their property. They submitted a 12-page memorandum with 14 exhibits, all making the case that their view is right and the department's view is wrong. So to me, that sounds like a contest. It might not be a contest like an appeal of a director decision or notice of violation, but it clearly is a contest to determine who is right and who is wrong. And given the fact that BVA Rule 12-801-28 states in relevant part, All departments in the county shall be admitted as parties upon timely application for intervention. I'm asking the board to grant the department's petition to intervene. Thank you.
Okay, thank you. All right, Ms. Paris?
Thank you, Chair. The county does not deny that this is not a contested case. They've admitted so much. The rules of the Board of Variance and Appeals, 12, Section 801-65 is what governs the procedure.
Sorry,
for
Chair, I don't know if
disposition.
you're getting an echo on your end. I'm sorry, there's a bit of an echo here. I
Yeah.
don't know if you guys are doing it. It's making it a little difficult for me to hear. I don't know if there's anything that can be done to resolve that, but I think it would help for everyone to be able to hear you clearly because it's coming through as an echo for me.
Is that Michael who's talking?
Yeah, sorry, this is Michael Hopper. I just wanted to note that so we could get a clear transcript and also.
If I use this microphone, does it still echo?
No.
Okay, thank
No,
you.
no.
Yeah, that's better.
If I
Are
may
you-
begin again, thank you. Chair, the county here has admitted that this is not a contested case. The applicable rules, section 12-801-65, governs the procedures for the disposition of declaratory ruling petitions. And those rules do not include scheduling the petition for a contested case hearing. And those rules do not mention intervention. The rules that the county references that allow intervention is specific to contested cases. That rule is included under subchapter 3 of the rules, whereas declaratory rulings are governed by subchapter 6. For those reasons, just because this is a dispute or just because the department has a different opinion as to the interpretation does not mean that the department is a party to this case. And the rules contemplate the board having the ability to make a determination as to the applicability of any ordinance, statute, rule, et cetera, as it relates to the ponies. So we would request that the petition for intervention be denied because there's no rule that authorizes it.
Sorry to interrupt, Ms. Paris. So could you mute that please real quick? So really fast, Chair. We can't hear you in the meeting right now, but really quick. Chair Hecht, Member Hecht and Member Weiss have mentioned that they can't really hear too well with the television audio on while someone in person is speaking. So what they're asking for us to do is mute the television while they are speaking in person. And then if we could get your help, like if you guys have something to tell us or say something, if you guys could raise your hand, we can see you visually. So then we can unmute the television so that you folks can speak. It's just the members here in person can't really hear what the person in the meeting room is saying with the television is on. But we have to have the television on in order to hear you folks online speak. It's an unfortunate situation, but we're trying to troubleshoot. So if that works for you folks, we'll unmute and see what your guys' thoughts are on that. Does that work? Unmute the TV, please. Chair, what are your thoughts?
Well, I would like to proceed here, so if this is the only way we can do it, let's, yeah, everybody mute and raise your hand when you want to speak, okay? All right.
Thank you so much, everybody, for helping us with this.
You start again.
Oh,
You start again. We can show.
you would like Ms. Paris to start again, Member Weiss?
She could.
Oh, okay, so Member Weiss and Member Hecht would like Ms. Paris to repeat her statement since they couldn't hear what she was saying.
Thank you. It's difficult for me to hear my own argument here. I apologize for how it came out. The planning department here has admitted that this is not a contested case. The rules that apply to intervention petitions are included in subchapter 3 of the BVA rules, and that subchapter is titled Intervention and Contested Cases, indicating that intervention is only applicable in contested cases. Where there are other administrations that allow for intervention in declaratory rulings, those agencies have the rules of their declaratory rulings section that specifically allows for intervention in declaratory rulings. So for example, DLNR allows interested persons to to intervene in proceedings for declaratory orders. The Hawaii Labor Relations Board, Hawaii Public Employment Relations Board, they all have specific rules that state that any party may intervene in declaratory ruling procedures. However, here, subchapter 6 of the rules is what governs the rulemaking procedures and declaratory rulings. And subchapter 6 does not include any specific references to contested cases or an interested party's right to intervene. So because this is not a contested case, then the department has no right to intervene, and we would request that the petition for intervention be denied. Iris, you gotta unmute.
Okay, so I guess we need to have a discussion on this, board members. And I've got some questions here to ask. My personal feeling is that I don't know why we're hearing this, because it was a land use ruling and Maui County Council. This was not a planning department ruling on these.
Chair.
Yes.
Chair, I think just for now, we're going to hear the issue of the petition to intervene, whether to allow the county in or not, and decide that, and then hear from the parties on any sort of merit argument from the actual petition itself. So just a reminder, but I think the first thing to decide is the department going to be in as a party or not in as a party?
I totally understand that, Mr. Hopper, sorry. I guess where I'm going with this is, personally, I would like to have the county involved, because otherwise we do not have anybody there that is going to present an opposite side to the facts that are being submitted to us. So I would like to hear from the rest of the board members to see what kind of consensus we can come to. So I open the floor to the board members to discuss this.
Hey, whoa, can you mute? This is Weiss. Can I address the attorneys directly or just put it out there? I have a question on the fact that it's with the code you just referenced or whatever site you just referenced, was it prohibited? Was it prohibited the county cannot intervene, or was it just silent on the issue?
So Member Weiss, is this a question for your counsel, Mr. Hopper, or is that who you're asking of your question?
Whoever can answer it, if that's that's the only avenue I have.
Okay, because if your question is to Mr. Hopper, we need to turn the television back on since he's online so he can speak to everyone and we can all hear. So we'll unmute for Mr. Hopper.
So the question is that in the.
Yeah.
And what petitioner's counsel just cited, is it silent on the issue, or is it specifically prohibited that the county cannot intervene in this case? I know they said they can't, but I didn't hear that it was prohibited, or it just didn't mention, like, was it silent on the issue?
Chair, this is Michael Hopper. You definitely do have the ability to ask these questions to legal counsel for the parties. You could ask each of them and have them respond too. If you want my advice on any of these issues, we could potentially go to executive session and discuss with respect to this. I'd probably prefer that. But I don't think there's anything prohibiting you as board members from asking questions to legal counsel who just made their arguments before you if you have clarification questions for their arguments. So I think I'd advise as a first step to ask that legal question of the parties. And then once you get all your questions answered by the parties, we could consider either an executive session to discuss with me, or you can go into your deliberations. But I think it's pretty common to have questions for a legal argument for a petition like this. I think it's pretty common to have board member questions, just as a judge in a case may have questions for legal counsel if they made a motion before a court. So I think you can certainly address your questions to legal counsel.
Can maybe mute it then. Is it muted? So what you just cited, is it prohibited or is just silent on the issue of intervention?
I'll answer that by pointing first to HRS Section 91-8, which governs, that's the Hawaii revised statute that governs petitioning agencies for declaratory orders. That statute, among other things, says that each agency shall adopt rules prescribing the form of the petitions and the procedure for their submission, consideration, and prompt disposition. When you look to the rules of the BVA under subchapter 6, section 12-801-65, it lists the ways that a declaratory ruling petition could be considered and disposed of. And it does not include, or otherwise it is silent as to intervention in that rule.
Okay, that's all I need. Thank you.
Mr. Work, would you like to address this question?
Well, her answer is accurate. It's silent as to the issue as far as Member Weiss's question. I agree.
Members, do we have any other questions or any discussion here? Questions for either of the attorneys? Who's trying to speak?
Member Lee, your audio's on.
Is someone in the room there trying to speak? Was that David Weiss or somebody else? Because I hear no one.
No, Chair, none of the members are speaking at this moment.
Yeah, let her know I've got my answer.
Member Weiss felt like the responses from both parties was sufficient for him.
Okay, board members, do we have any further discussion here?
Was that going to go to executive? If we're going to discuss, did I hear council recommend that to go into executive to discuss it?
Well, Chair,
Once we've addressed the attorneys?
Chair,
Maybe I misunderstood.
Yes, who wanted to speak? Was that you, Michael?
yes, hi. If you can hear me. I wasn't suggesting we have discussion of the motion in executive session. Executive session would be if you had legal questions for me on the item with respect to the board's rights, duties, privileges, liabilities, and immunities, for me to advise you on any of these questions. I think your discussion on this should be an open session. So a motion, second, discussion of a motion, things like that should generally be done in open session. But if you did have legal questions on this issue for me, I think doing that in executive session would be allowed and probably preferable to doing that in open session. But it would be for the purpose of legal questions and not to actually deliberate on the item.
Thanks. This is why I agree with, excuse me, I agree with Chair to allow the county to intervene.
Anybody else want to make a comment?
I agree.
Can I have someone make a motion?
This is why some make a motion to allow the county to intervene in this case.
Second.
Okay, we have a motion to allow the county to intervene made by David Weiss and seconded by Ivan Lay. Is there any further discussion from the members of the board? There being none, Could I have a show of hands of those who are in favor of the motion? May I have hands? Well, except I can't see in the boardroom.
Member Weiss and Member Hecht have their hands raised.
Okay, so it's unanimous. So we are going to let the county intervene in this case. Okay. So moving along, I think the procedure that we are going to be following today, since this is
Chair,
yes.
just sort of a reminder, there was a filing by the county of Maui in this case. I don't know if they're a party, the next step would be to accept all of the filings from the parties in this case. Or if you've formally done that. I know that there was an objection to not just the intervention, but also looking at the county's submission. I don't know if that objection still stands now that they're a party, or if you wanted to, you could consider, I think, a motion to accept all of the filings to date from the parties to move on to the next step. But I wanted to maybe suggest that because there was an objection to the county filing a response because they weren't a party. If they're a party, you may want to take action to, I think, adopt or not adopt, but accept everything, all the filings from the parties to date.
Thank you, Mr. Hopper. I believe that makes sense. Do we want to make a motion, since we have accepted the county to intervene here, that all documents submitted by the county shall be admitted into evidence? Is that what we want to call it?
Yeah, I think it's not really evidence necessarily. Some of it is, but I think we'll have those documents admitted as filings, I guess, or considered as filings. If there's, I guess at this point, you could see if there's any objections from the parties of anything that's been submitted at this stage. But I think that would be the next step. You're not going through an appeal process right now, so it's not quite as formal as that. But there was an objection to, I don't think there's necessarily any county objections to what's been filed by the petitioners, although they just became parties. But there was an objection to considering the county's filing. And so you just may want to clarify that you're going to consider the everything that's been submitted to date, both legal argument and exhibits that have been submitted. You can maybe check with the parties first if there's any objections to that. And if there is, consider them and then make a ruling on that to determine that. But I think it would maybe help the record to see that if the parties' filings to date is going to constitute what you make your, base your decision on. So maybe first step is check with the parties if they have any objections to the items that have been filed in this case by the parties being considered by the commission, and then and go from there.
Okay. I'm assuming that, Mr. Work, you have no objection to our submitting the filings to this hearing, correct?
Yes, no objection, but I would like clarification because there have been instances in the past where the board did not receive everything that the county or the other parties have filed, especially when they're filed past the deadline. So can I go through the list of what has been filed and ask what you have received and what you have not?
Certainly.
All right, the Pognies filed their petition for declaratory ruling and exhibits A through L on May 25th, 2023. I'm assuming all the board members received that.
Yes.
And the Pognies filed additional exhibits M through P on December 3rd of 2024. Did you receive that?
Yes. Anybody not receive it?
And the department filed it. Oh, we already covered that. The department filed a hearing memorandum on November 27th, 2024. Did everyone receive that?
Good thing.
I see Ned heads affirmatively nodding. And
Okay.
then the department filed Exhibit XX on December 6th of 2024. Did you receive that one?
Yes.
Great. And then the last one is the Pogny's objection to the department's memorandum with Exhibits A and B filed on December 9th of 2024. Did you get that?
I do not have that. But if, do the other members have that?
Chair, it was sent too late to send to you physically. So it was sent to everybody. Chelsea Kwan sent that to you by email yesterday.
Okay, well, I was out of town and I was able to download the document from the petitioners, but I did not see the other one, so.
I'd just like to state for the record that the final filing from the Podneys was filed on December 5th, 2024. And if Mr. Work, you could repeat the date that the department filed Exhibit XX, because I don't believe I have record of that.
December 6th, 2024. And the Pogny's objection to the department memo was served on Corporation Counsel on the 5th, but it wasn't filed with the department until the 9th. So there's two filing dates on that one.
Okay.
And just for the record, Chair, the department has no objection to admitting, obviously, the department's filings and exhibits, and no objection to the Pogny's filings and exhibits.
Okay. Thank you, Mr. Work. Okay, Ms. Ferris? Do you have any objections to these filings being admitted?
No, we do not have objection to the filings being admitted, but to the extent that the board hasn't received or reviewed all of the filings, we would have an objection to continuing with the hearing prior to the board's receipt and review of those.
And
I don't have the date here, but I exchanged emails with Ms. Kwan. I believe it was within the last day or two, and she returned a file stamped copy of our submission with a file stamp dated December 5th. If I'm not mistaken, I'm trying to pull it up, but it's difficult on my phone.
Okay.
But it appears from what has been said today that not all board members have received all of the documents.
I am the only one, I believe, who said anything about not receiving the ones that were sent yesterday. And that if I recuse myself from that portion, then I believe we still have enough quorum to go ahead and proceed with this hearing. Do you have an objection to that?
Chair, which filing are we talking about that? And first of all, you probably should confirm everyone's read it, but what filing are we talking about here? Are we talking about the response to the department's?
No, I did see the one that was the response to the partner, the one that was December 11th from the petitioner. I did not see, apparently the county sent a couple other things that came on email yesterday, or the last thing that I had received was I did receive the Exhibit XX. But he said something about, Mr. Work, was it an A and B or something?
That was, yeah, go ahead.
To clarify, Chair, the document that has on it that essentially states that it's the petitioner's objection to the county that was filed, that says the date stamp 12/11/2024 with exhibits A and B.
Yeah,
That Chelsea Kwan sent to you yesterday by email.
I have that.
Yeah.
That date is correct. I did double check that. Thank you.
Okay.
And the chair confirmed that it received everything that the department filed. So I think we're good.
Yeah, is there anything in that list that anybody on the BVA has not had a chance to review? Because I think the objection from petitioner was you don't want to go forward with the hearing unless people have reviewed everything. And I just want to clarify, are there things that have not been reviewed by the board at this point? So let's clarify that. Chair, I thought you had said there was something you may have missed, but let's clarify what that is so we can figure that out maybe. Or if any other party anybody else on the board has not read any of those things mentioned, let's get that clarified too.
No, we just clarified that with Chelsea about what was sent yesterday, and I have it here and I read it.
Okay, so it appears that no board members, that there's nothing that was mentioned as a matter of record here that the board members had not reviewed. And if that's the case, it sounds like there's not really any objections because the objections seem to be to the extent that parties or the members hadn't reviewed or received any of these. So let's just be careful to make sure there's nothing missing or nothing that's been filed that the board hasn't had a chance to review.
If I may, this is Sharon Paris. The petitioners have not received department's filing XX. I don't recall when Mr. Work said that was served. We have not received it yet, so we would object to that being included as a document, given that we haven't had a chance to review it.
I believe you have it among your papers in a different section, the exact same thing. This is the exchange with Jordan Hart, which I think I saw in earlier documents.
Okay, if it's the identical exchange, then there's no objection.
Well, to have candor with the tribunal and opposing counsel, this is Jordan Hart's email the day after the one that you sent. So he basically retracts the entire statement that he makes in the email. I believe it's on August 10th. And then on the 11th, that's exhibit XX, where he says, I made a mistake. I retract all of that. I'm surprised the Pogneys didn't include that in the full correspondence to the board.
Well, the email wasn't received by the Pogneys and we haven't seen that exhibit. So the objection to that exhibit stands because we haven't had a chance to review it yet.
Okay. So
Was there a date of service on that exhibit? It looks like it says it was filed on December 6th.
it was, but there's no date of service.
Right. Can we confirm if this exhibit was filed? Was a copy of it served on the opposing party, or do we have a record of that? I mean, I can access it here on the website, but I don't know if it was served on the party or when they would have gotten it, or if we have evidence of that for the board's consideration. Okay, I mean, I guess all we have is that something was filed with the board. We don't know if it was served on the applicant and then the petitioner, and the petitioners objected to that. It sounds like all of the other documents at this point can be considered by the commission. And then there's a pending objection to any consideration of this exhibit here before the board would make any sort of decision. So I guess that's where we're at, Chair. If you want to move on with the understanding that the record is all of this without exhibit XX at this point, then I suppose you can. You could also rule on that objection if you find some more information on when this was served and feel comfortable doing that. So I think those are your options.
Well, and I think the other option is whether Mr. Work feels that this exhibit is an important a document for his case. And if it is, and Ms. Paris has said she did not receive it, then I don't think we can continue. So, Mr. Work, is this document important to your case?
No, I think it's a distraction from this case, but the Pogneys brought it up by bringing up Mr. Hart's emails having to do with a property that's not even related to the Pogneys to try and prove a point that the department was treating them unfairly. So I think it's good to have a complete record of that conversation regarding that unrelated property. But at the end of the day, I think it's a distraction from the ultimate point of this case.
All right, so I am going to suggest then that we do not accept Exhibit XX as one of the documents submitted in this case, and it is and we can continue. Is everyone all right with that? All right, so I guess then at this point in time, we need to hear from the petitioners, put their case forward, and then I believe we will hear from the county, and then petitioners can rebut, counties can rebut. Does this sound like a reasonable procedure?
Yes.
Then we'll have questions from the board. All right. Okay, if we may proceed, Ms. Barros, I believe you said you had a PowerPoint presentation.
Chair, this is Michael Hopper. I think on behalf of the board, request that both parties address the issue of the board's legal authority to grant or to issue a declaratory ruling in this case. There were some issues raised on that, and so if both parties could address that for the board's benefit, I think that would be beneficial as part of their presentations.
Okay, so you want it as part of the presentation rather than separate from?
I mean, I guess that's up to the board, but if you want them to include that as, I would advise you to have that included, because if there's an issue raised with the ability to issue a declaratory ruling in this case, then I think that's something that should be addressed by both parties. It was raised in the county's documents, and there was a response from the petitioner, but that's an important issue, I think, for the board to consider in issuing the declaratory, and whether to issue the threshold issue of whether this is a proper item for a declaratory order, and then if that you do issue the order, which your order is going to be. So I think that's just one issue that I think is important for you to have the parties address. And rather than asking them to do it after their presentation's done, you could ask them to do it before separately, or you could ask them to do it as part of this. But I think it's a good thing for both parties to address.
Yeah, I agree with you. I'm of a mixed opinion here, because if this is not, I mean, if we decide it's not within our purview, then we've wasted a whole lot of time listening to both sides of this argument. But I don't know how we can determine whether it's in our purview. I do have some questions about that. I guess I will ask Ms. Paris.
I mean, yeah, Chair, if you want to just have them go through their presentations to make their cases, but include that, I think that's fine too, just to be clear. But I think that's something that would be important for both parties to address, just to sort of clarify what I was saying.
Okay, why do we not proceed under this recommendation from Mr. Hopper, that you all explain to us why you think this should or should not be under the purview of the BVA? All right, and so Ms. Paris, can you include this in your discussion here?
Yes,
Your
yes, Chair.
Okay, thank you. I'd like to proceed then.
Thank you, Chair. Is the TV muted?
An echo
Okay,
going.
thank you. Thank you, Chair and board members. So at the Chair's request, at the outset, I will address why we believe that this petition for declaratory ruling is proper before the board at this time. And that is based on section 12-801 65A or 801-65 of the Board of Variance and Appeals rules, which allows a party to seek a declaratory ruling as to a statutory provision, rule, or order of the department or board. And so here today, what we're doing is asking the board for a declaratory ruling as to the applicability of statutory provisions to the PODNIs. And those statutory provisions are in the form of ordinances. As we've included in the objection that was received on December 12th, ordinances are treated the same as statutes. They are laws, they're rules of action and rules of guidance for the people of a municipality. So statutes and ordinances are treated the same under the law. And the issues in this case, as you will see through our presentation and as you've read through the briefing, involves how the applicability of multiple ordinances are affecting various uses on the property. And so the Board of Variance and Appeals has the ability to issue a declaratory ruling as to its interpretation of those ordinances on the uses of the property. So today what we're asking for is a declaratory ruling as to the effect of the hours of operation limitation that's included in a conditional zoning ordinance on the Pogneys' operation of a TVR or other residential uses at their property. Next slide, please. Hayden and Wendy Pogney are with me in the room today. They're local family Maui residents for over 30 years. They started a retail business on Front Street in the year 2000, and that business grew to 4 stores stretching from Lahaina to Kihei at one point. Wendy currently works as a hairstylist. She's won awards in the community for her work. And she operated Soleil Luna Spa and Salon at the subject property, which we'll discuss later in the presentation. In the year 2001, the Pogneys began purchasing long-term rental properties to supplement their income. And in 2004, they purchased the subject property, which is located at 242 Lahaina Luna Road. Next slide. In case the board is not familiar, we wanted to orient you as to the location of the property. Now, obviously, this is a picture of the area prior to the wildfires, but we wanted to give some context as to the general neighborhood and the vicinity. If you look on Lahaina Luna Road, there's a blue dot. I apologize if it's difficult to see, but it's the top corner of Lahaina Luna Road and Honopi'ilani Highway. So if you look at the corner of Lahaina Luna Road and Honopi'ilani Highway, it's the second house in from the corner with the blue dot. And that is the current location of the property. Next slide. So as mentioned, they purchased the property in 2004. The property is currently zoned B2, which is Community Business District. At the time the Pogneys purchased the property, as I'll discuss, there were limited uses allowed of the property. The property was dilapidated. There were numerous cars in the yard, and it really hadn't been very well taken care of. So the Pogneys, took on this property as a project to improve the current neighborhood. Next slide, please. These are just a couple more pictures of the status and condition of the property when they first purchased it, and a closer up picture of where the property is located on Lahaina Luna Road. When they purchased the property in 2004, the property's uses were governed by ordinance number 1585, which had been placed into effect on October 28, 1986. Ordinance 1585 is Exhibit A to the petition. That ordinance changed the zoning of the property from R2 residential to the B2 Community Business District. However, the ordinance also imposed some conditions. So if you look on page 4 of Exhibit A, number 1, under section 2, the first condition imposed that's relevant to this proceeding is that the use of the property shall be limited to a furniture sales building with office and storage space. And under that, paragraph 2 said that any other uses shall be subject to review and approval by the Maui Planning Commission and County Council. So between 2004 and 2007, the Pogneys underwent a process that was listed in ordinance 1585, number 2, that any other uses shall be subject to review and approval by the commission and the council. And so they went through that process before the commission and the council to get additional uses approved. Next slide, please. In 2007, ordinance number 3494 was passed in October. That ordinance is Exhibit B to the petition. The ordinance applied to 2 properties, 232 and 242 Lahaina Luna Road. So the Pogneys and their neighbors next to them. 242 is the property we're talking about today. So as you see in Exhibit B to the petition, Ordinance 3494, it did a few things. First of all, it affirmed that the parcel was zoned B2 Community Business District. That's in Section 1 of that ordinance. When you turn to Exhibit E of the ordinance, it has revised conditions of zoning. And those conditions included B2 Community District uses that would be prohibited. And it also included certain B1 neighborhood business district uses that would be prohibited. When you have a B2 property, B1 uses are allowed in the B2 property. And so B1 has separate uses than B2. And so that's the reason for the difference between B2 and B1 in this ordinance. In addition to these prohibited or excluded uses, that was the first condition of the property. The 8th condition, which is page 2 of Exhibit C to the ordinance. Condition 8 said that the hours of operation for all uses shall be limited to 7 a.m. until 9 p.m. Another provision in this ordinance that's relevant is paragraph 2 on the same page, which said all other uses not permitted by this ordinance shall require a further change in zoning. Next slide, please.
I'm sorry. Could you repeat
This
that?
slide just summarizes what those prohibited B2 uses were at the time that Ordinance 3494 was passed in 2007. Next slide. And this slide lists the excluded B1 uses. What these exclusions meant in this ordinance is that any use that was allowable in the B1 and B2 zoning that was not included on these exclusions was therefore a permissible use of the property. So if you go to the next slide, the next 2 slides will outline in 2007 all of the different uses that the property was allowed to have. So this represents all of the B1 uses that were permissible under the zoning ordinances at the time of 2007, except for those that were excluded by Ordinance 3494. This did include the barber or beauty shop, which is what they ultimately opened. It also included a single family dwelling or living and sleeping quarters above a business. It also included a bed and breakfast. Next slide, please. This is a list of all of the B2 uses that were permitted under Ordinance 3494 as of 2007, which again was all of the B2 uses at the time, with the exception of those that were specifically excluded. And you'll see that this is a lengthy list of uses. On the second column, a couple that I'd like to point out are nursing and convalescent home was permitted, as well as bed and breakfast under the B2 use as well. Next slide. So after the Pogneys were able to get the permitted uses of the property expanded, they undertook to open the salon and beauty spa that they had planned to do. They remodeled the home. They, increased the curb appeal drastically from the dilapidated building that they had first purchased. Their intent in remodeling it was to keep the historical look and feel of historic Lahaina town. And they operated that salon from the year 2007 until 2020. The business wasn't the most profitable, and so they decided that they wanted to apply for permits to revert the building back to its original home so that they could use it as a transient vacation rental. And one of the reasons that they had decided that was because as of 2017, the uses in the B2 district had changed. And so the TVR use was now included as a permitted use of their property. Next slide. So in 2013, the county code was amended by ordinance number 4088. That's Exhibit D to your petition. So what that ordinance did was amend the section of the zoning code that governed the permitted uses in the B2 district. And one thing it did was it added transient vacation rentals as an allowable use. TVR was listed as number 67 in ordinance number 4088. There were some conditions on TVRs under that ordinance that a TVR could not exceed 20 bedrooms. And then although bed and breakfast had previously been an allowable use in the B2 district and the B1 district, ordinance 4088 now restricted those bed and breakfasts to only those that had been lawfully existing in single family dwellings at the time. Now, the county argues in its opposition to this petition that ordinance number 4088 does not apply to the Ponies property. And there's simply no merit to this argument because ordinance 4088 is an ordinance of general application that applies to the zoning code in general. And the zoning code applies equally to all properties in the county of Maui. This section of the zoning code governs the allowable uses in the B2 district. Now, in ordinance 3494, which was the conditional zoning ordinance applicable only to Pogni's property and their neighbor's property, said additional uses would require a change in zoning. This ordinance 4088 was that change in zoning. Now, everything on this new list in ordinance 4088 that was a permissible use would be allowed at the Pogni's property as long as it was not included as one of those that were explicitly prohibited by ordinance 3494. So in other words, if I can make this a little bit clearer, ordinance 4088 in 2013 updated section 19.18.020, which is the permitted uses within the B2 community business district. And, you know, it has a list of 67 uses, at least 67 uses. And of these 67 uses, the only ones that the Pognies would not be allowed to do under ordinance 3494 are those uses that were specifically crossed out or listed as excluded on their conditional zoning ordinance. Now, because TVR was not restricted on their ordinance 3494. And remember, bed and breakfast was also not prohibited under that ordinance. Because TVRs were not listed as being excluded, that was now a legal permissible use of the Pogni's property. Next slide, please. So with the changes in allowable use in 2013, the Pognies began the process of submitting for permits to convert their residence to a TVR. The photo that you see here and on the next slide shows you the result of the renovation that was completed in 2021. And again, the intent was always to maintain the character of the neighborhood and have a residence that would add, you know, value to the neighborhood. Next slide, please. So again, this is what the property looked like in 2021 after the renovation and before the fire. So the process, excuse me, for getting the approvals they needed started in approximately 2019 when the Pogneys submitted their building permit application. In that application, they originally proposed that they were going to convert their existing residence to an inn. Next slide. However, the Zoning and Enforcement Division noted that under the 1918-020 permitted uses for B2, they noted that inn was not a permitted use. And so the Pogneys planner reviewed the allowable uses, confirmed that TVR was included in the list of permitted uses, and that TVR was not included on the list of excluded uses under Ordinance 3494. And so she replied to the department to please change the usage to TVR. And so in subsequent correspondence, the department acknowledged that this dwelling will be used as a TVR. And at that time, the department never raised any issues with the proposed use of the property. Next slide, please. So the following just outlines the emails that show those conversations that we just referred to. This first email is Exhibit G to your petition. And, you see here under paragraph 1, they say inn is not permitted use in the B2 community district. And next slide. The same exhibit, when you look to the top of the exhibit, you see Ms. Mitchell's response, and she says, thank you, please change it to transient vacation rental as is set forth in the B2 ordinance. Next slide. This next email is Exhibit H to your petition. This is the issuance. This is regarding, the permitting still. The department is confirming this dwelling will be used as a TVR. They're stating that it's a dwelling and it's still classified as residential occupancy, and therefore a certificate of occupancy will not be required. Next slide. And then this last email is Exhibit H to the petition as well. And the planner confirmed that the building permit application would be occupied as a dwelling and will be utilized as a TVR, which is a permitted usage in this zoning. And as we'll outline a little bit later, all of the building permits were approved under these representations, and nobody from the planning department ever disputed that TVR was a permitted usage in the zoning. So this next slide is referencing the planning department's interpretation of the very same condition on a neighboring property. And this goes to the email that Mr. Work was referring to, the correspondence. And we do believe that this is highly relevant to the dispute. So in April of 2020, April of 20.
Yes.
I'm sorry, I believe it's August of 2022. That's an error. In any event, as you see on the email, Jordan Hart, who is a Department of Planning, Zoning and Enforcement Division employee, had sent an email to the Pogneys neighbor. And this email was on the interpretation of permitted uses. What this email was about is a parcel at 252 Lahaina Luna Road. On the bottom of this email, it says subject parcel. You see the address. You see it says amending ordinance 1537 B2 conditional. Ordinance 1537 B2 conditional was analogous to the original ordinance 1585 that applied to the Pogneys property. That was an ordinance that had also changed 252 Lahaina Luna Road from a residential to a B2 zoning, albeit with extreme conditions attached. Underneath at the very bottom, you see Ordinance 3495. Ordinance 3495 is also very analogous to the Pogneys Ordinance 3494. That ordinance you can see as Exhibit A to our objection to the department's hearing memorandum. Ordinance 3495 was also passed in 2007. It applied to 252 Lahaina Luna Road, and it reaffirmed that 252 Lahaina Luna Road was zoned B2, and it had virtually the same restrictions and conditions as the Pogny's property with respect to the excluded uses and the hours of operation limitation. Next slide, please. So in this email, Mr. Hart is quoting what Maui County Code 19.18.020 at the time read, which was the B2 Community District. And he noted that transient vacation rentals not exceeding 20 bedrooms were allowed. He also noted that Exhibit B of Ordinance 3495 did not prohibit transient vacation rental use. Transient vacation rental use is therefore included as one of the uses permitted in the B2 Community Business District. So this is the same reasoning that we're applying here to this situation. Because Ordinance 3494, just as 3495, because those ordinances say these properties are B2 properties, you can have any B2 use that's legally allowed except for this list. So anytime the legally allowed B2 uses change, therefore the uses that you can do in your property also change as long as it doesn't fall into that except for category. And so what Mr. Hart said in this email is that TVR did not fall in the except for category, and therefore it was a permitted use. However, he noted that the condition on the hours of operation would still apply to this use. Next slide, please. With respect to Mr. Hart's interpretation of what the condition on the hours of operation applying to a TVR would mean, he specifically stated, in reference to condition number 6 of Ordinance 3495 and transient vacation rental use, no operation associated with a TVR may occur at the subject parcel outside of the permitted hours. That would include checking guests in or out, providing front desk or concierge service, selling activities, general maintenance, cleaning, associated events, and any other functions of operation. So this email indicated TVR use was allowed and that the hours of operation restricted these types of active business operations that would be associated with that type of an operation during the nighttime hours. Next slide, please. So fast forwarding to the approval of all the Pogny's permits, they got all of their permits approved by the department, which included a building permit, electrical permit, 2 plumbing permits. And these were all permits issued with the knowledge that the residence would be used as a TVR dwelling. Now, the department and the county were so aware of the intended use of this property that the wastewater administration even required the Pogny's to install a sewer manhole that would be large enough to support a 20-room TVR, which was the maximum allowable size, even though they never had any intention of, running an operation, which would virtually be a hotel. They did have to comply with this condition to be able to obtain their building permits. The Pogny's, are always cognizant of the community and the feedback of their neighbors. And so they also made sure that the neighbors supported their TVR use. There's never been an allegation anywhere in this situation that any business operations associated with TVR use were occurring between 9 p.m. and 7 a.m. And the Pogny's have received multiple letters of support from their neighbors, which are Exhibit N to our supplemental petition submission. And so the question that's to be answered today, because unfortunately this property did burn down during the fire, and the Pogny's are interested in rebuilding their property. But before they're able to do that, they need to know how Condition 8 is going to be applied to future uses of their property as a dwelling when they rebuild. And that's very important because it applies to not just TVR use, but other residential uses. So we'll walk through how this question should be answered. the specific question is, are the Pogneys permitted to have overnight occupants in the residential dwelling, which is in the B2 commercial business district, if there's no active business operations associated with that occupancy, such as check-in, maintenance, sales, things of that nature? Next slide. And so to answer that question, we want to look at three things. The first being just basic rules of construction, the second being vested rights, and the third being estoppel. And vested rights and estoppel pretty much go hand in hand. Next slide. So with respect to the rules of construction, you know, it would be easy for somebody to look at condition number 8 of the ordinance 3494 and say, well, it says no uses overnight. So that's the end of the story. But we don't believe it's that simple, because if a construction of a statute or a rule would produce an absurd result, the underlying legislative intent needs to be looked at. And that's just a common doctrine, a legal doctrine. And so when you look at the original ordinance 3494, if it were true that no use at all could be allowed overnight, then it would not have made sense for the Planning Commission and the county to have allowed uses such as a single family dwelling, or living and sleeping quarters above a business, or a bed and breakfast, or a nursing or convalescent home. All of these uses were allowable under 3494. But if you were to then say, well, you can have a nursing or convalescent home, but you're not allowed to operate between 9 p.m. and 7 a.m., that would make the permissible use of a nursing or convalescent home be redundant or absurd. It just wouldn't make sense. And so the intent that you have to look at is, what was the intent of the hours of operation prohibition? And we believe that the intent of that prohibition was against true business operations, things that are going to bring people, noise, activity to this neighborhood, which is partially business but partially residential, at all hours of the night. So for example, you don't want your hair salon operating at midnight. You don't want food deliveries to your nursing home happening at midnight. But can your nursing home residents sleep in the home at midnight? I think that the intent there was to prohibit the business uses of the business district and not the residential uses. Next slide, please. And then, if you say, well, nursing or convalescent home, it must be prohibited because that's a business. So you just can't do it. There's really no difference between a long-term rental, a short-term rental, or a nursing home when it comes to a business purpose. So the nature of the use is commercial or for business in each case. But if you were to say that just because it has a business purpose, it's not allowed, that would also give an absurd result, because it would mean that you couldn't even have a long-term rented out single-family home, because that would be a use of the property overnight. And I think that's also an absurd result. So if the prohibition on the nighttime hours of operation was meant to apply to something as simple as overnight occupancy, then it would apply to even residential use if that use has to do with a lease or a money exchange. And we don't believe that that was the intent. And we believe that, in addition to just common sense, the reason that we know that that wasn't the intent is that the department itself did confirm that the condition is only meant to prohibit nighttime business operations associated with a TVR, again, such as checking in or out, these types of things that cause noise and disturbances. Next slide, please. So the other principle at play here is vested rights, and due process principles protect property owners from having their vested property rights interfered with. And here, the government agency, which was the Department of Planning, granted formal permission to the Podneys to proceed with their project, which was converting their salon into a residential TVR. And in doing so, the Podneys have acquired a vested right to complete that project as approved. And they did in fact complete the project as approved. And they did in fact operate their project in that way. Next slide, please. And so estoppel is a legal principle that would apply if the county were to now change position and claim that the landowner no longer can use the land that same way. Here, the Podneys have relied to their detriment on the approvals that they received. They would never have converted their property to the TVR had they not gotten all the approvals with the permits, including handwritten on the permits that it is intended to be a TVR. So when a landowner changes their position based on official assurances that they have a right to rely on, then the government is stopped from taking a change in that position. Next slide, please. This is just more case law supporting. Oh, one back, please. This is just another case, for the same principle that where you've expended an enormous amount of money in reliance upon the existing zoning laws, and you're given assurances of some sort by a planning department that your proposed construction meets those laws, then you have to be given the right to proceed with your project in accordance with those assurances by the planning department upon which you relied. Next slide. So again, the Podneys, and this is an image, unfortunately, of the house. The Podneys are trying to find out how this condition against uses between the hours of 9 p.m. and 7 a.m. is going to be applied to their property. Will they be able to reconstruct a residential dwelling? If they put a long-term family in that dwelling, will they be told that they're violating the condition because the dwelling's being used overnight? If they start a TVR again, will they be told that they can't have guests in the house overnight because that violates the condition? If they have a nursing home, will they be told that the nursing home residents can't be there overnight because that violates the condition? Next slide, please. And so we believe the answer to this question as to whether the Podneys are permitted to have overnight occupants in their residential dwelling, as long as no active business operations are associated with that occupancy occur between the hours of 9 p.m. and 7 a.m. And we believe the answer to that question is yes. And so we would request that the board issue a declaratory ruling that that is what the meaning of the prohibition means. Thank you.
Thank you. Sorry. Mr. Hopper, at this point in time, I think I would like to let board members ask questions before we go on to Mr. Work while everything is fresh in their mind. Is there any problem with that?
I think that's okay. I think it's also, it's also permissible for you to finish with Mr. Work, and then you may have questions you want to ask both parties. I would say it would be good to address the issue of whether, again, you're asking the BVA, and to me, this is, I think, unprecedented to make a declaratory ruling on a county council ordinance that would presumably be binding on the county and the planning department. And so I think addressing that issue as to whether or not this is the proper vehicle for the board to make this determination I think is something both parties should address for you, so you can have that as a determination. So if you want to proceed with questions, that's fine. Again, I think you should get that argument from both parties on that issue, and if you want to proceed with Mr. Work, ask questions to both parties, that's fine. If you want to ask questions now, that's fine too, I think.
Board members, do you have any questions at this point in time for Ms. Paris? I know I do. Does anybody else?
Well, this is Joe. You had said about when they did their presentation, each to just basically say why we have the power, like why did they come to the BVA, right? For this, should we go like have her explain that and then go? That wasn't really part of it, right?
That's
Isn't
kind
it?
of where I was going to go with my
Yeah.
question on her right now. So yes. Ms. Paris, you know, as has been mentioned, we are or I am kind of curious as why you came this route. When there was a notice of warning, you didn't pursue the appeal route, or the fact that this was a land use decision, and yet you're coming to the BVA for a declaration on something that really involved, it was the county council and the land use commission that did the ordinances. So just a little curious as to why you think we have the purview to rule on this in your favor.
Thank you, Chair. These ordinances are County of Maui ordinances. I'm not aware of any difference between these ordinances and any other ordinance or statute. And the declaratory petition rules of the BVA specifically state that any person may petition the BVA for the interpretation as to the applicability of any statute or rule. And so these ordinances are statutes or rules. With respect to the notice of warning and violation, that was appealed and that was dismissed in light of the situation in Lahaina. We do believe that this is a situation that could potentially arise again in the future. And so to avoid any doubt, and again, so that the ponies know how this will be interpreted by the board, imagine a situation where they rebuild their property. They open a nursing home, they rent out their home, they have occupancy of their home, which is an allowable use of the B2 under the ordinance overnight. And then they get hit with a notice of violation again. And then they go through the process and they appeal it and they come all the way up to the board. That would kind of be wasteful if we can come to the board in the first instance and ask the board, how will you interpret this condition? We want to proactively prevent a situation where we're on the side of an appeal, and we want to get a determination as to the board's interpretation of condition 8 and how it applies condition 8 to residential occupancy uses that are allowable under the ordinances.
Anybody else have any questions at this point in time?
Sorry, this is Joe. Maybe a stupid question, but so last time when the zoning was changed, what is it? If I have my notes, like 2004, whatever it was. I mean, that wasn't the BVA that made those determinations, right? It was the zoning was changed from Maui County. So why it seems like that's where they should be going, right? I mean, or maybe that's a simple explanation. I'm just trying to as far as who can determine this and make those changes.
So we're not asking for any changes to be made. Anytime any individual has a question about the applicability of any statute or rule, they can go to the agency that's responsible for interpreting that statute or rule, and they can ask that agency for an interpretation of that statute or rule. And that is part of Hawaii's administrative rules, the statute that I cited to earlier, HRS 91. I'd have to find the citation, excuse me, HRS 91-8, which says any interested person may petition an agency for a declaratory order as to the applicability of any statutory provision or of any rule or order of the agency. So here, this is any statutory provision. It doesn't matter who passed it. It doesn't matter if it's a Hawaii revised statute passed by the Hawaii State Legislature. It doesn't matter whether it's an ordinance passed by the County Council of Hawaii. It doesn't matter whether it's conditional zoning that was approved by the Maui Planning Commission. The statute is unequivocal, and it says that any interested person may petition an agency for a declaratory order. And so the Pogneys are any interested person. They're coming to the agency, the Board of Variance and Appeals, which is the agency that interprets, zoning uses and how the zoning violations are applied to people. And they're asking this agency for the interpretation as to the applicability of the provision of the ordinance.
This is member Bianca. That totally makes sense to me. I feel like this seems right that they are before us. I feel like I'm missing something to think that they wouldn't be. It seems normal.
This is Weiss. I'm going to take an opposite opinion. I don't ever recall anybody seeking declaratory judgment, only coming in front of this board in a matter of appeal of a violation or asking or seeking a variance. So myself, I think it's not the right venue. And if we just stick to variance and appeals, like the board, I think that the cases that we see all the time, that's what my recommendation would be.
Member
Well,
Bianca.
Chair, maybe now, again, these are questions for one party. We could hear from the other party as well. But for now, I think we're still on questions rather than making a final decision on any of the issues right now. So just as a reminder, I think it's good to have the questions asked that we need to ask now, hear from other side, complete your questions, and then go into deliberation and decision making. But let's keep that open until we come up with hearing the arguments from all the parties, just as a reminder.
Now let me revise that statement and ask a question. If the BVA wasn't an avenue to seek this declaratory judgment, where would be the other body you would seek it from in the county? What other avenues would you have?
There are no other avenues. Respectfully, your position is directly contrary to Chapter 6 of your rules, which is entitled Rulemaking and Declaratory Rulings. So I agree that this may be an uncommon type of proceeding before the board, but it's definitely not the only type of proceeding that the board has the authority to do. And if we were to, for example, file in the circuit court tomorrow, the circuit court would kick the case and they would say that we failed to exhaust our administrative remedies. And they would point to the rulemaking and declaratory ruling rules governing the Board of Variance and Appeals. And they would tell us, you should have gone and asked the Board of Variance and Appeals for a decision before you came to the court. So there's no other place for us to go.
But if we pass on it, then your avenue would be to go to court. And you would satisfy that issue that the court might have that you didn't seek some kind of judgment from this board.
We have appeal rights of orders of this board, but I'm not sure if I understand your question.
The question was, see if I can, you said that if you went to court and they would kick it because you had not exhausted all your efforts. But if we decide not to take this up, you would then, your next.
We would appeal that decision in court, yes.
Okay. All right, thank you.
Arlene, I know you want to ask.
Oh, yes. Yes, sorry, I just had a question. It seems like it's just the way the thing is worded and the type of uses is conflicting. Seems like the cleaner thing to do would be to go back to the county council that created these ordinances and, have it clarified, have better language. Like say, for example, if you are going to use TVRs, then kind of spell out that the intent is to just restrict the business, operations during that time, but then still allow people to sleep in overnight. So I'm just thinking, we can kind of beat this thing to death, interpretation wise. And you probably could go to, a number of board of variance meetings, and because of the personalities, you might get different results. But I'm thinking the cleanest thing would be go back to the council and get these ordinances clarified.
Is this a question for?
Yes. So don't you think that would be another avenue to go down before you exhaust all your administrative efforts?
No, I think that again violates the intent of Chapter 6 and the declaratory ruling procedures. Declaratory rulings are used not just in agencies, but courts too. Like you can take a statute that you're confused about and you can go to a court and you can ask the judge to say, Judge, what does this statute mean? The judge can't just say, well, why don't you just go to the legislature and make them change it to say what you want it to mean? I'm not going to tell you what I think it means. I mean, that would just be the judge abrogating his or her responsibility to give a ruling as to his or her interpretation of what it means. And so, sure, if somebody wants to change a rule, they can try to do that. We won't need to change a rule if the board confirms that our interpretation is correct, which we believe it is.
I have another question for you because I think we have two things at play. Are you, okay, what exactly are you asking the board to rule on? Are you asking us to rule on the fact that this can be a TVR and that they can operate, where they don't have to follow the rules as outlined in the ordinance? Because I think part of the question that's involved here is, according to the county, whether you can really even legally be a TVR. And I know you're arguing estoppel, that they've gone through all these things. The county is saying this was wrong, and you did not have the ability to be a TVR in the first place. So what exactly is the nature of your request before this board?
Thank you for that question. It is a good question because it does identify two major issues. So with respect to the county's position that TVR is not allowed, that's a position that we first heard in the objection or the memorandum, the hearing memo that was filed. In the notice of violation, it did not say that TVR wasn't an allowable use of the property. What it said was that our TVR use violated condition number 8 of Ordinance 3494. We don't think it's disputed that Ordinance 4088 amended the zoning rules and added TVR as allowable uses in the B2 zoning district. So no, that's not a question that we've come to the board to ask the board for its interpretation of. What we are asking for today is whether the prohibition on uses between the hours of 9 p.m. and 7 a.m., does that apply to mere occupancy? Does occupancy alone count a use that is prohibited by that condition? Or does that condition only prohibit uses associated with active business operations?
Okay, I totally understand that. I don't understand why you didn't just appeal and go that route then.
We did appeal and the appeal was dismissed.
Oh, really? I was not aware of that. Okay.
So we appealed, the appeal was dismissed because the house burned down. And so the issue didn't come before the board as an appeal. But because this issue is likely to arise again in the future, if we were to just resume operations under our interpretation, we're coming for a declaratory ruling, which is another way of saying like a preliminary answer. So rather than waiting to get a violation and then appealing that and then trying to resolve that on the back end, we're trying to get the answer on the front end.
Okay. I did not see anywhere in here the final permit to operate as a TVR. Did they have the actual permit to work as a TVR?
There's no permit necessary. So it's just an allowable use. It's a permissible use under section 19.18.020 under ordinance 4088. So for uses that are permissible, you don't need to apply for a special permit.
Okay, any other questions? Okay, I think I'd like to move on with Mr. Work, please.
Thank you, Chair. I'm assuming all of the board members have received and read and reviewed the hearing memorandum that the county has, that the department has provided to the board. I will just cover those arguments again briefly to state the department's position. First of all, on the petition to request a declaratory ruling, the department takes the position that that should be denied or the board should refuse to issue it because the ordinance in question, 3494, is a land use ordinance that's specifically focused on the Pogny's property and the adjacent property only. Doesn't apply to any other properties in the county. It's not a general statutory provision or code provision that applies to all B2 zoned properties in the county. It's unique to them. So I'd argue that it doesn't meet the applicability of being a statutory provision, a rule or order of the department or the board. Understand if the board wants to proceed and grant the petition anyway and go to the merits of the case, I will argue that 242 Lahaina Little Road, as was stated, was zoned R2 until 1986 when it was changed to B2, but it was severely limited to only one use, a sole use, furniture sales building. Both of these properties by this ordinance, 1585. The Pogny's purchased this property with this severe limitation knowingly in 2004. The only thing they could do there at that time was a furniture sales business by ordinance 1585. So they went to work, as was described, to expand the permitted uses. And they worked from 2004 for 3 years to 2007 with the land use committee to get the permitted uses expanded. They told the committee they intended to use the property as a beauty salon. They told them the business hours, that's why they're in there. And this process is thoroughly documented in Exhibit L. I encourage the board members to read through it. It's a long document, but it really shows what the Planning Commission and the Land Use Committee was concerned about in expanding the uses at this particular property and the adjoining property. It describes how the Pogny's were heavily involved in this process. It shows how they went through repeated meetings of adding to the prohibited and excluded uses. So this property might be zoned B2, and the Pogny's will argue it's B2 generally, but we know and they know, and you can see in Ordinance 3494 that this is still a severely limited B2 property. It's not like other B2 zoned properties in the county. So when this 3-year process was over, this is what was passed by the County Council, Ordinance 3494. I encourage the board to look closely at that. You'll see that there are many items that are prohibited by the County Council and excluded from a typical B2 zoned property. You can see also in Exhibit L, I'll ask you to take a look at page 11, is where the Land Use Committee was concerned about additional uses, unexpected additional uses cropping up and being applied to this property. And so they put in that very specific language that any other uses not permitted by this ordinance shall require a further change in zoning. And what the Pogny's Council focuses you on is a further change in zoning, arguing that Ordinance 4088 is that further change. But I would ask the board to really put the emphasis where it belongs, and that is by this ordinance. Any other uses not permitted by this ordinance, Ordinance 3494, shall require further change in zoning. So just like Ordinance 3494 modified the preceding very limited Ordinance 1585, Ordinance 3494 governs the permitted uses on the Pogny's property, and that would have to be amended in order for there to be an expansion of uses. And I would note at the time that Ordinance 3494 was enacted, transient vacation rental use was not a permitted use in the B2. So what I would argue that the Land Use Committee and the County Council, when they passed Ordinance 3494, is that that modification to the prior ordinance, 1585 was an expansion of the use of the property, but it was still severely limited by all of the uses that were prohibited and excluded. Now, the Pognies argued that with the passage of Ordinance 4088 in 2013 made transient vacation rental use a permitted use at their property. But I would say that that was a general ordinance that modified the county code for B2 districts in general. It did not modify Ordinance 3494 in any way. And again, I'll point you to that. I think it's item 2 within Ordinance 3494. Any other uses not permitted by this ordinance shall require further change in zoning. No change in zoning was done to affect Ordinance 3494. So the TVR addition to B2 districts generally does not apply to the Pognies property. I would argue that if you take a look at Exhibit L, the committee's overall approach when they're having these ongoing meetings with the Pognies and many others to decide how the permitted uses would be expanded at this property, their approach from the very beginning is to severely limit it, to keep it severely limited. They keep adding prohibited uses and excluded uses. And nowhere in Exhibit L do you get the impression of the Pognies interpretation that the committee was contemplating that a general change a general change in a B2 zoning, such as Ordinance 4088, expanding permitted uses at the Pognies property. There, it's clearly they want it limited. They want it to be static at that moment in time. In 2007, only the uses that were permitted in B2 and B1 was also included that are not specifically prohibited or excluded at the time of enactment. And again, TVR was not an allowed use at the time. It became an allowed use later in 2013. Now, the Pognies also argue that the department approved transient vacation rental use, and they give you these emails going back and forth. And I point out in my hearing memorandum that it's clear that neither the Pognies agent who's interacting with the county official contemplate the effect of Ordinance 3494 at all. They simply go to what are the standard B2 uses allowed at that time. And the Pognies agent changes it to one that fits at that time. None of them consider the effects of the very limiting Ordinance 3494. The Pognies knew that their property was limited to that, but their agent didn't, and apparently didn't tell you their agent. So there's a veneer of approval, and this back and forth of emails between the Pognies agent and the department official cannot override the limitations imposed by the county council's Ordinance 3494 on this particular property. And finally, they give you Mr. Hart's email in August of 2022 that he's approving TVR use with the same limited business hours at the property at 252. Again, I'll point out that that is a different ordinance and a different property completely. I'll agree it has similar limitations, but I find it curious that they did not give you, the board, the complete conversation between Mr. Hart, because the very next day he retracts that email in its entirety. But given all of this, I just ask that the board either deny the petition for declaratory ruling or refuse to issue a declaratory ruling, or if inclined to give a declaratory ruling, that it give that ruling in favor of the county's position. And I've outlined those points in the hearing memorandum. Thank you.
I have a question for you, Mr. Work.
Yes.
This is a matter of semantics, but the words change in zoning. Now, to me, a change in zoning is going from an R1 to a B2, or that is a change in zoning versus a change in what can be done within a zone. So the semantics here are very important, and I'd like some clarification.
I think looking at Exhibit L and really getting the mindset behind the Land Use Committee and their recommendation ultimately to the council to pass 3494, indicates that their view of change in zoning indicates changing the permitted uses in the zone for these two particular properties. It's not changing it from B2 back to R3 or something like that. It's staying B2, but it's changing the permitted uses or the prohibited uses is how I read it in context.
Thank you for that clarification. Board members, does anybody else have questions for Mr. Work?
This is member Vial. Yeah, I don't see where these two TMKs are specifically excluded from the B2 zoning. What am I missing? Where's that?
With the passage of 1585 in 1986, with that ordinance, the property was rezoned from R3, R2 residential to B2, but it specifically excludes all uses except for one, the furniture sales building is what it describes in that ordinance. I believe you have that exhibit. I don't remember what letter it is offhand. But does that answer your question?
Kind of. So you're saying that that only was that specific ordinance was only relating to those two TMKs, correct?
That is correct. And then that ordinance is then subsequently modified with the POGNY's input with the enactment of ordinance 3494 because they wanted to expand the use so that they could do a beauty salon there.
Okay, and so once it got expanded into the beauty salon use, so that doesn't that mean that 3494 takes the place of 1585?
Yes, it amended or modified 1585. But if you look through 3494, you'll see that it's still extremely limited in that many of the normally permitted uses in the B1 and 2 are prohibited or excluded. So you have to go through the prohibited excluded use at the time that it was enacted in 2007 against what was permitted to really define what was permitted and what is permitted at this point in time. I think the PowerPoint kind of showed some of that.
So correct me if I'm wrong here, really what's in question here is whether subsequent ordinances can have power over a ordinance that is only applicable to specific properties. In other words, a general ordinance, which is changing what can be done in a B2 district, it does not have broad brush over all previous ordinances. Because you just explained to me that, okay, the change in zoning means a change in uses. So this is back to their reasoning is that a subsequent ordinance changed and gave more uses. So help clarify this for me.
Yes, it's the ordinance 3494 is very specific to these two TMKs. It modifies the previous ordinance 1585, which also applies to only these two TMKs. And the land use committee added the language. You'll see them describing how they were concerned about uses being expanded at these two TMKs beyond what they were doing with this ordinance. So they specifically put in there on page 11, you'll see we want to add into the proposed legislation this phrase, any other uses not permitted by this ordinance shall require a further change in zoning. So the only way that the uses could change in the mind of the land use committee in recommending this legislation was if 3494 was modified, just like it modified the ordinance before it, applying to these two specific TMKs.
Anybody else have any other questions? Okay, so.
Do I have an opportunity to respond to the county's argument?
To
the planning department's argument?
Yes, please, go ahead.
Thank you, Chair. I think the board may have picked up on this, but the prior use restrictions on the property dating back to Ordinance 1585 are not relevant here. We don't, we know that the property was limited in uses. We don't dispute that the uses were limited. The limitations on uses doesn't answer the question that's before the board here. The Ordinance 3494 didn't say, the department is reading into it language that doesn't exist. It's reading into it language such as any other use is not permitted by this ordinance shall require a further change in zoning through a specific amendment to this specific ordinance. It doesn't say that. It just says shall require a further change in zoning. I fail to see how Ordinance 4088, which is a bill for an ordinance amending the zoning code of the County of Maui relating to the B2 Community Business District, does not apply to the Pogneys property. There's no carve-outs in 4088 that says, however, these new uses shall not apply to any properties to which conditional zoning ordinance applies. What Ordinance 3494 did is it said that certain B2 community district uses were prohibited. It didn't say only the B2 community business district uses allowed as of today are allowed. So the ordinance didn't permit specific uses. It said you can use your property as a B2. It didn't include a list of what the B2 uses were at the time, likely because the commission and the county were aware that the B2 uses do change over time. The zoning ordinances do change over time. If the commission and committee intended to freeze the property at a certain moment in time and only allow a discrete list of uses, then instead of saying we'll permit B2 except for this group, it would have said, we will only allow these specific uses. It wouldn't have needed to do this thing where it says, okay, B2 uses are great, but you cannot have these specific uses. And then it would not have needed to recognize that B2 uses may also change in the future as long as it's a change in zoning. If the department's position is to be believed, then that means that the Pogneys property as it sits there today is only allowed to do the uses that existed as of 2007. And as we outlined in the PowerPoint, we compiled a list of what those uses were in 2007. And so if the department's argument is correct, then that means that bed and breakfast under both B1 and B2 would still be an allowable use of the property under the department's interpretation. If that's the case, it doesn't matter whether we're talking about a bed and breakfast or a TVR or a residence above a business or a nursing or convalescent home. The question that the board is here to answer is still the same. When condition 8 says that the hours of operation for all uses shall be limited to 7 a.m. until 9 p.m., what does it mean by the word operation? Does it mean the hours of business operation, meaning activities incidental to the related business, activities incidental to a nursing home, such as receiving deliveries, having medical staff come in and out, having ambulances arrive at all hours of the night, activities incidental to the operation of a bed and breakfast, which would be checking guests in and out overnight? Or did they mean that the hours of operation for all uses meant that even the occupancy of the dwelling uses that were allowed cannot happen? So regardless of which, we think the department's interpretation that Ordinance 4088 doesn't apply is just, it defies logic. We don't believe that that's true because that ordinance modified the county code for the B2 zoning in general. But even if the county's position is correct, it still means that the Pogneys still need an answer to the question because under the department's position, they could have a bed and breakfast. So then our question will convert to, can they have a bed and breakfast occupied between the hours of 9 p.m. and 7 a.m. as long as they're not conducting business operations associated with that bed and breakfast during those hours? Thank you.
Mr. Work, you have any other comments?
Yes, I just encourage the board to look closely at Exhibit L. It really gives you a insight into the mindset of the Land Use Committee. It documents thoroughly how they looked at these two properties and their concerns about having a wide breadth of uses, and they really wanted to limit it. There's nothing in their analysis or discussion that would give the indication that they anticipated new uses being added. It is completely one-sided in eliminating uses and restricting uses and not allowing new uses unless it was specifically modifying this ordinance. I'll just encourage you to take a look at the actual wording and documentation from the Land Use Committee in Exhibit L.
Board members, any further questions?
And Member Vial, just look at Exhibit L real quick.
I'm sorry, I didn't hear if that was a question.
Oh, sorry, I was just trying to stop. This is Member Vial. I was just trying to make sure we didn't rush ahead for a minute because I'm looking for Exhibit L.
I'm personally still confused as how this can be operating as a TVR, given the county's argument that this was restricted by land use. So, Ms. Paris, do you have, does the property have a permitted use to operate at TVR?
So two answers to that question, Chair. The first is that the notice of violation issued by the department never said that the property was not allowed to operate as a TVR. It simply said that the TVR was in violation of condition number 8, which states that the hours for all uses shall be limited to 7 a.m. until 9 p.m. When you're asking what is, I'm taking the question to mean what's the evidence that the property is allowed to operate as a TVR? And again, it's the fact that the property was converted from an R3 to a B2 property. When it was first converted to a B2 property, it was only allowed to have one use. That use that it was allowed to have was specified. Then that condition was removed, and in place of that condition specifying which use was allowed, the ordinance said you can have B2 uses except for a specific list of B2 uses. Any additional uses requires a change in zoning. That change in zoning occurred later in 2007 when ordinance 4088 was passed that added TVR as a permissible use in the B2 district. The property was a B2 district zoned property, and TVR did not appear on the list of excluded uses, just as bed and breakfast did not appear on the list of excluded uses. And so as of 2013, the property was then permissibly able to be used as a TVR, which was confirmed by the department beginning in 2019 when the Pogneys applied for their permits and when they received their permits in 2020. In 2022, there was another ordinance that again changed the permissible B2 zoning. And this time it allowed no new TVRs, but it allowed TVRs that were operating and in existence as of a certain date. to continue operation. And so, the Pogneys TVR was existing as of the date of that 2022 ordinance. And so therefore, it was still a permissible use. There's no separate permit, there's no separate document saying that it's allowed, other than a plain reading of the zoning code, which lists all of the uses allowed in B2 and the relevant dates that those uses are applicable, and comparing that with the list of what's prohibited by the conditional use ordinance. And when you match those two lists together, then you get what's left over. And what's left over is any B2 use that's currently permissible.
And I would encourage the board to take a look at Exhibit K, and that is the letter that council is referring to and continues to repeat that the county never raised the issue of TVR not being allowed. But if you read that entire letter, you see that they cite Ordinance 3494 and say it's in violation not only because of the hours, but there's evidence that the county suspected violations of short-term rental home, bed and breakfast, and transient vacation rental and timeshare. So to say it's the first time the TVR was raised as a violation is not true. You can look at Exhibit K.
Chair, this is Michael Hopper. Could I address a couple of things? Yes. First, I don't know how long we have quorum as far as continuing deliberations on this, if there's a recess consideration or if it looks like we'll be able to come to a decision. I also had a question, if I could possibly ask the parties regarding the declaratory order applicability, because I really want to try to get this clarified, if it's something that you would allow.
Please.
So HRS 91-8 states that any interested person may petition an agency for a declaratory order as to the applicability of any statutory provision or of any rule or order of the agency. Doesn't the statutory provision, rule, or order have to be of the agency? In other words, I don't think the BVA could go around and issue a declaratory ruling on an HRS statute and have that be binding, certainly not on the state. And, on the county, I don't see how the BVA would be able to do that. Wouldn't these be more reserved for issues like if the board issued a variance and there was a question on the applicability of the variance or conditions of the variance that the board itself raised, or that the board itself had control over, or of the interpretation of one of its own rules that it adopted. But if you're talking about looking at a statutory provision that the county council passed, are you saying that the Board of Variances and Appeals has the authority to issue a binding interpretation on any statute or rule that's not a BVA rule or statute? Or are you saying they have the authority broad enough to issue that type of ruling on sort of any part of the county code? Because I think that would help sort of clarify the board's purview here versus hearing an appeal of a decision of one of those agencies, which under the charter, it does clearly have that power to do. So having that clarified, I think would help, because I would assume that the parties would say there's some limits on the declaratory order abilities of an agency, because, doesn't that have to be on a statute or rule or order within that agency's, that's of that agency as specified in the statute? Just to help the board, I think maybe Chair, if you're okay with it, having both parties address that issue, because I just want to make sure we're not overstepping what the rules allow.
I agree. Okay, so I guess the question to you, Ms. Paris, is since this was a ruling initially by the county council and the land use committee, why did you not go before them to have them change the wording in their ordinance?
So again, HRS 91-8 provides that an interested person may petition an agency for a declaratory order as to the applicability of any statutory provision or of any rule or order of the agency. Now, rules and orders of the agency applies to the agency. Agencies issue rules. Agencies make orders. This board has rulemaking authority under Chapter 6 of its rules, and it has the authority to issue orders on, appeals and contested cases. The agency doesn't have the authority to issue or make statutory provisions. However, HRS 91-8 still provides that agencies can issue declaratory orders as to the applicability of any statutory provision. There's nothing in this that says that statutory provision has to be a statutory provision promulgated by the agency at issue. I think Mr. Hopper is correct that the statutory provision that you're seeking a declaratory ruling on has to be of the subject matter that falls within the jurisdiction of the agency. So here we're asking for an interpretation of an ordinance under the subject matter, under the jurisdiction of this agency. An ordinance governing permissible uses of a property and what those conditions mean is something that this agency makes decisions on all the time, as this member pointed out earlier, when it hears appeals. So again, we can get this question answered on an appeal retroactively. There's this procedure that we're doing right now, which is to get this question answered proactively. And so there's no difference between whether a notice of violation is issued and then we appeal the notice of violation and ask this agency for an interpretation of what the condition means versus coming and asking the agency for an interpretation of what the condition means before a notice of violation is issued. And that's the key. If what Mr. Hopper is saying is correct, that would mean that anytime anybody has a question as to what something meant, you would have to go to the legislative body that passed that law. And that's just not what the rules contemplate.
Mr. Work, comment?
Yes, as I've argued before, the department's position is that this is a land use ordinance, ordinance 3494, that they're asking for a declaratory ruling on. It is not a statutory provision generally applicable to all properties, nor is a rule or order of the department or the board. Therefore, the rule that they're proceeding under, 12-801-65 of the BVA rules that pertains to declaratory rulings, would not apply to this land use ordinance. So I'd ask that the petition be denied on that basis, or that the board decide to refuse to issue a declaratory ruling for lack of jurisdiction.
I'm hearing no further questions or further discussion. I think in the interest of time, board members, can we have a discussion here and come to some kind of a decision? I know it's a toughie.
Oh, this is member Shibuya. I just one question for Mr. Work. That's what I would call like a blanket 4088 ordinance that talked about B2. Because this specific parcel had a specific ordinance with conditions. Is it correct to say that these blanket ordinances wouldn't automatically apply to whatever conditions were assigned to that specific parcel as far as their changing zoning?
Yes, that's the department's position, is that the ordinance governing 3494 governs these two specific parcels, unique and apart from all other B2 zone properties. And when 4088 was passed in 2013, that applied to B2 generally, but it did not change ordinance 3494 in any way.
Yeah, and it looks like, when I read into L, the land use committee, had specific concerns, and that's why they assigned, like certain things, and then they asked that if other uses were to be requested, that they go back to have the change in zoning amended. Is that my correct interpretation
That is
of what?
that is the department's position, yes.
Yeah. Oh, okay. Thank you.
It's a question for Mr. Work. This is Member Vial. So just to follow up on that, so are you saying though that the only guidance for these two Team Ks is the furniture store thing? They didn't get bumped into 3494. They're still in 1585.
No, not at all. 1585 was the original ordinance that changed this from R2 residential to B2, but with only the 1 year, the furniture store. And then the Pogneys bought the property with that limitation, and they were able through the land use committee to get a recommendation to pass 3494, which modified the previous ordinance 1585. So the governing ordinance is 3494, which modified the prior more limited ordinance.
So they are governed by 3494.
That is the department's position, yes.
And the department's position is that it or they change it from the furniture store to the spa or whatever, and that's where it stands.
Correct. And any other uses that were permitted at the B2 zone at the time it was passed in 2007 that are not explicitly prohibited or excluded by ordinance 3494.
I have a question. It seems like to me we're looking at a rather broad question, and I think it's a fairly narrow question. It has to do with that 1 hours of operation. It doesn't seem like there's another issue here on the table. It seems like the county has accepted the short-term rental of the property. It just seems like they're trying to use the hours of operation to stop the short-term rentals. It seems like as a board that we should be looking at just this one issue, which is the hours of operation. That's what they're asking for. They're not asking for a change in land use.
No, the department's position is that transient vacation rental use was not permitted at the time that ordinance 3494 was passed, and therefore it is not a permitted use to this day unless 3494 is modified.
So the county's position is a land use issue, not that condition.
Well, that condition is a sub-issue that the Pogneys have brought up because they assumed that the county was against transient vacation rental use because of the hours of use limitation. That's one other consideration, but it's secondary to the first one, which is whether or not TVR is a permitted use on the Pogneys property based on ordinance 3494. And the position of the department is that it is not.
So it's really a short-term rental issue, not a condition.
I'm going to interject here procedurally. Are we both able to address? I mean, I didn't believe that we were still in a question and answer phase of the attorneys. And excuse me if that was a question directed to the county, but I'd also like the opportunity to respond if it was a question directed to the county. I think that your original question was spot on. And it shows that you understand exactly what the issue is and that the county has tried to bring in all of these other issues. But our position is that the way you described it is correct.
However, following up on that, if we were to rule to change the hours, the county still can come back and say, but you can't be a TBR. So the two are very much intertwined.
If that's a question, we don't disagree with that. And we're not asking for a change in the hours of operation. We're just asking for the board's interpretation of what specific things that limitation prohibits with respect to residential uses, whether it's TVR use, whether it's bed and breakfast use, whether it's a nursing home, whether it's a long-term residential rental, whether it's an owner occupying the residence above their business, all of those allowable uses. And the Pogneys need this answer because they need to know what to put in for to rebuild their property.
So we could go ahead and rule in your favor and say, yes, the hours of limitation do not apply to residential use or a home or something like that. And you could get that, but you still may not get a permit to use your place as a TVR.
That is correct, and that would be a separate fight that we would have to have if that were to come into that issue. But again, we don't believe that we would need a permit for the TVR. But again, these are all separate issues, and that would be a separate fight. And as the party that brought this petition, we have brought the petition on one singular issue, which is what the member pointed out, which is what does the hour of operation limitation, what is that intended to apply to?
Thank you. Any other discussion here? Does that help clarify anything for anybody here?
And Chair, this is Michael Hopper. If you do need an executive session, I'm available for that as well.
Do you all feel you want an executive session, or do you feel you are in a position where you know what you think? Can I have some comments, please?
I have a comment. This is Member Vial. I mean, I agree with the petitioner that it seems absurd that that's nursing homes, B&Bs, that's all allowed there with this time restriction, but not a TVR. They're zoned B2. So it just seems like it's just a blanket that just makes sense to me. So the argument just that it seems to be with conviction, it seems correct. But then I don't know what to do to help them either. I mean, I don't know what to do to help that because that is right now the code says this thing about. So I think even if we say, yeah, we agree, that doesn't make any sense that they're going to allow residential, you can live there, you can rent it out long term, you can have nursing homes, you can have a B&B, but you can't have a TVR, even though it's zoned business. And so therefore we know you don't need a permit. None of it makes any sense that, because then it just seems like as long as that time zone thing is implemented, I don't know what we can do to assist in any way. That's my commentary.
How about something to the effect that the wordage on the hours of operation only applies to its operation as a furniture store or subsequently as a beauty salon and spa, and does not extend to other uses because that was what it was restricted to. Okay, so those rules, while they're saying the ordinance was specific for the specific uses, then the rules were only for those specific uses and not necessarily applied to other uses. How does that sound?
I could support that if there was a motion.
I'm good with that.
If I may just interject, we've requested the specific ruling that we would like, which is in our petition. And that's the requested relief here. And I could read that to the board if you'd prefer.
Go ahead.
This is on page 8 of the conclusion of our initial petition. We request the BVA issue a declaratory ruling that, as applied to the Pogneys TVR, Condition 8 does not prohibit the overnight occupancy of the property and only means that no operation associated with TVR use may occur at the property outside of the permitted hours, such as checking guests in or out, providing front desk or concierge service, selling activities, general maintenance, cleaning. associated events, or any other functions of operation.
Are you talking about, okay, I'm not finding those exact wordage. This is the cover here and before Exhibit A. If I get to page 8, I do not read what you are reading. So where are you finding this?
I don't know how your exhibits are numbered. This is on the conclusion of the original petition that was filed on May 25th, 2023.
Yep, that's what I have here. And it says conclusion, based on the foregoing, the Pugnees respectfully request that the BVA issue a ruling that as applied to Is this the one you're talking about?
Yes.
Yes.
It's in two spots. It's actually on page 2 as well. On page 2 of the actual petition,
Right, I have it
on the
here,
last paragraph.
but what you're missing out of what
For the
I'm saying,
reasons described more fully herein, petitioners respectfully request the BVA issue a declaratory ruling that, and then that lengthy paragraph that I just read.
right. Okay, here's where I have a problem with that, because you're saying applied to their TVA. And
We would be okay with doing it, that we would be okay with revising it that applied to their dwelling, as applied to their residential dwelling. Condition 8 does not prohibit overnight occupancy of the property and only means that no operations associated with the related business use may occur at the property outside of the permitted hours.
that is different than what I was saying.
Chair, this is Michael Hopper. Currently, the language says that the hours of operation for all uses shall be limited to 7 a.m. until 9 p.m. So, if you're going to have an interpretation on that, I think you need to be specific as to why it wouldn't apply and what those hours would not apply to. So, yeah, you would need to do that if that's what's going to be something you look to rule.
Well, what I'm saying is this applies to the rules as they stood at that period in time. So the uses at that period in time and not carrying it forward.
Well, Chair, that seems to be a separate issue. One is what the hours of operation are for all the uses allowed. The second one would be the uses allowed. And it sounds like you're talking about, you believe the uses were allowed, only those that were in place at the time of the ordinance minus the ones that were listed. That's sort of a different determination versus the hours. So I don't know if those are two separate things you want to rule on. Again, we can go to executive session to discuss this if you want some thoughts on proceeding in general and how to work on this. But that's if you're looking to do that, I think those are two separate issues.
To simplify our request, we could just state that the ruling is that condition number 8 on the restriction of the hours of operation does not apply to mere residential dwelling during those hours, or mere residential occupancy during those hours.
Hey, Chair, my thoughts are, I have no idea why hours of operation are even an issue. This is the busiest intersection on the west side. It's not quiet at any time. I still stand by, I don't think the board should rule, but if it comes down to the hours, what does it matter if it's, it's Lionel Luna and the highway. And it's really busy and it's loud and it's all the time. So I have no idea why this is even, I could understand why they did it because there's going to be probably B2 mix close to residential, but this is not the place.
So
And Chair, I also want to be clear. So you do not have the authority to modify this condition or change it at all. This is a county ordinance. You can, well, again, the issue of your ability to issue a ruling for here is still in question. But as far as the language, you would need to, you don't have the authority to alter the language, or if you think it's, a bad idea or something, say that the language is inapplicable, for example. So just to reiterate that for the board, because this is a zoning ordinance that was passed by the council and only they can modify that. So this is a clarification.
What would the judgment be? If it's a declaratory judgment and we make a judgment, isn't that effectively changing the ordinance?
That's changing the ordinance is definitely not something you have the authority to do. You would have to amend a zoning condition. And I don't even think the petitioners are asking for that. Hopefully, I'm assuming they're not, because that's certainly not something you can do.
But if they
yeah.
prevail, then that's not an issue, right?
Well, again, you are looking at what they're going to do, what you're going to do in order to dispose of this petition. And I had, again, raised the issue of the statutory provision. Is it a provision of yours or of someone else that you're interpreting? And again, you're not amending anything. You would have to essentially give a ruling on your authority, again, and I'll read it, is to give your ruling on the applicability. And so it's, I can read the language again. For a declaratory order as to the applicability of any statutory provision or of any rule or order of the agency. So that's what your jurisdiction is. And again, if you want to go to executive session, we can sort of clarify more as far as thoughts going forward on this. But just to clarify, you don't get to amend this like you would, for example, a variance. Let's say you granted a variance and you thought there was a condition in that variance that was problematic. That's something that you could actually amend and change. This is not one of your decisions, so this isn't something you could amend.
So maybe we go into executive session. Chair, what do you think? I have some more questions, so
I have one final suggestion for,
And then just for the
two
future,
ways we
Chair,
could
I
write
think
it.
for
The
Chair,
ruling would be that condition 8 of ordinance 3494 does not apply to residential type uses between the hours of 9 PM and 7 AM. That's a simple way of stating it. Longer way of stating it is how we had it on the PowerPoint. Under condition 8 of ordinance 3494, the Pogneys are permitted to have overnight occupants in the residential dwelling located in the B2 Commercial Business District at 242 Lahaina Luna Road if no active business operations associated with such occupancy occur between the hours of 9 PM and 7 AM.
So this is a question for our council. Can we just, this is Member Vial, can we just have a opinion, so BVA opinion that hours of operation was not intended for dwellings? Can we just have we just leave it as, this is our opinion record?
Well, you're being asked to issue a declaratory order to that effect. So I suppose you'd be asked to issue an order saying that based on the record before you, you do not believe condition 8 was intended to, again, this is a business district. So it's, to the extent it allows residential uses, you would want to go through that, see what uses are allowed, consider the council's intent in doing this, and see if they meant to exclude those uses. Again, I am still not clear on your overall authority to issue this declaratory ruling with respect to this item. Generally, you see these as appeals, and I agree you could overturn a department's decision that would be adverse potentially to a landowner. But this is the first time I've been in a case where proactively someone asked for an order interpreting a county council ordinance as to what it means. And so I'm a bit at a loss for the proper process for you to go about finalizing this. But it appears that you're being asked to say that 7 to 9 p.m. And I don't know if you're talking about, and again, if anyone's going to address the chair, they should wait to be recognized by the chair on this. But if the issue is, if the wording is residential occupancy, you're going to want to clarify the elephant in the room, which is, does that apply to transient vacation rental use? Because that's generally not, that's considered not necessarily a residential use in the same sense as long-term occupancy is. So I don't know if you want to clarify what this applied to. You'd also need a basis to say that. What's your basis of saying that the language for all uses does not include certain uses? So you need to come up with that basis as to why you believe that, and have that in the record. So that's where you're at. So I don't know if you meant you're looking to say that doesn't apply to residential uses allowed here. I would A, find out what residential uses are allowed here, and B, do you intend that to apply to TVR uses? Is that considered residential for you? Is that considered something that is a residential use, or do you consider that a commercial type use versus residential? Normally long-term residential use is what's discussed in the residential districts. So with that language being broad, I think you'll want to clarify that.
Do board members feel you have enough information that you want to make a decision, or do you want to go on executive session? We seem to be, yes, Ivan.
No.
I have one
I
more.
think it's out of our
maybe
jurisdiction
you're cleared
personally.
up
I
here.
really do. I think
And
it's
I don't
the
want to throw another
county.
fly in the ointment here, but neither party has addressed the fact that of all these uses, I might be reading it wrong too. Of all these uses in both these ordinances, the only two that have some provision attached to it is a mortuary, that they needed some approval, and TVRs and bed and breakfasts. They all refer back to 19.65. That's subject to the provision of, and I haven't heard anybody reference that provision unless I've missed it. So none of the other uses have anything tied to it. So maybe that there's something that really addresses it in that provision.
We didn't address that because it's irrelevant. It's like another provision that doesn't speak to any of the issues here.
Is the county's council agree to that? I mean,
I'm not sure I understood your question.
not relevant? If so,
Chair, I wonder if we're still trying to complicate this a lot. It seems like to me, if we just look at it as a condition that really doesn't seem to apply to overnight residential use, we could go ahead and make a motion. And if we did, I think it ought to be the simple motion, not the more complex one. Gets into all sorts of areas that we really don't have the ability to judge at this time.
So
Yeah.
Yeah, no, Harry, I understand you're bringing it back to the basics. They would then have to prove that they can use this for residential use or TVR or anything else like that, because that's the other part of this issue. So
Chair, respectfully, that we wouldn't want that concern to prevent you from doing a motion such as what was just suggested, because if we need to go down that road later, then we would.
Chair, just to reiterate again, you're sort of you're not in deliberations on a motion now, but if parties want to be recognized, they should, try to get the chair's attention and just be clear that, that you're okay with them speaking, just to maintain order. It's not been a problem, but I just want to make sure if you want to have questions addressed, you can have them addressed. But it's generally, we shouldn't have parties talking without the chair recognizing them or members.
Okay, thank you, Mr. Hopper. So, Harry, what you want to, do you want to state a motion?
I'd like to use the wording, the short version wording that was suggested. If we could have that wording again, because I think that was my thought.
Well, whose wording was this?
And
Are
I
you
would,
talking-
I would make that motion. Could you state the wording for that again? The short one, not the long one.
The short one, yes. The board finds that condition number 8 of ordinance 3494 does not apply to overnight residential type uses between 9 PM and 7 AM.
That is my motion.
Okay. Would somebody like to second that?
Member Vial, I'd like to second.
Okay. Any discussion?
Chair,
Yes.
this is Michael Hopper. I don't know if I can make a comment now.
Go ahead.
I think there's a motion on the floor.
Yeah,
Yeah, if there's,
we're discussing it.
but by residential type use, do you mean to include transient vacation rental use or not? That's I think an open term, and you should say what you mean on that.
We could say overnight residential dwelling occupancy.
Transit road.
Does that work for you, Mr. Hopper?
What's your intent? Overnight dwelling occupancy, are you saying long-term residential use of the property? I mean, that's a way, as defined in the code, to deal with non-TVR's long-term residential use. If you mean to say residential type, overnight accommodations, but that includes TVR use. So that's
Mr. Hopper,
long-term residential.
respectfully, there was a
that's what
pending
I'm looking
motion
at.
on the floor.
Yeah, and I'm the
And
legal
I
counsel
think
for
it's
the
you that keeps
department.
interrupting these proceedings at this time, and you're not a board member, but
So, the chair,
what we've
Chair.
stated is that the condition doesn't apply to overnight residential dwelling occupancy. If in the future it needs to be debated what residential dwelling occupancy means, we can have that debate or discussion in the future. What we're simply seeking today is a ruling as to the board's interpretation of the condition based on the board's understanding of those terms.
Chair. If I may.
Okay, Mr. Hopper, yes, okay.
With a pending motion on the floor, the legal counsel assigned to the board, my job and my duty is to make sure that you understand what you're voting on and the wording of the condition. Legal counsel for one of the parties speaking during that proceeding is, in my opinion, improper. They are not your attorney, neither is Mr. Work. I'm your attorney in this matter. So I'm giving you legal advice on your motion so that you can have clarity on it. That's my job. That's why I am here. So if you don't want to hear from me and want to continue, that's fine. You can say you no longer want to hear from me. But I'm saying the motion as is leaves open one of the major issues that you have discussed in this proceeding. And without that clarity, you won't have that resolved. So I wanted to let you know that. And had I not said that, you would not have that advice and you would not perhaps know that and would probably be a bit upset that I did not give you that advice. So that's
Mr.
where I'm
Hopper.
at.
Thank you very much for that. So my question to you is, how would you amend the
That's the state transit.
pardon? Well, yeah. How would you amend the proposal to make it so that it's not ambiguous?
It depends on what you want. Or do you believe that this limitation was not intended to apply to all residential uses, including permitted transient vacation rental uses? Or do you believe that applies in a more limited fashion? That's
Mm.
up to you to put that in your wording. Again, I have concerns with the overall jurisdiction of this matter, as has been raised. But if you're going to do that, it should be clear either way. So if the members believe that this condition does not limit the uses of any residential type use, including including legal transient accommodations, something like that, you could say that. If you believe that it does not limit any long-term residential use of the property, you could also say that. So those are the two different wordings that I would say, depending on your intent.
Mhm. But in doing this, we are not legitimizing the fact that it can be used as a TVR, correct? We are only saying that this wording doesn't apply to TVRs or residential use. I think, because I think they're two completely separate issues. And you know, I mean, I think it's logical to say that anytime it's a residential thing, you don't limit the hours, as was stated. So I could be okay with doing that as long as I am not in the process saying that they can legally do this as a TVR. Because going back to my initial comment was this restriction was placed for a specific use of the property. And so to me, it only applies to that specific use of the property. And the question then for the applicant or the declarant, the petitioners, is whether or not they can legally use it for the other things. And that's not what we're discussing today. So I want to say that the wording is pertinent only to the uses at that time. If they wanted to change it and expand it, they would have to go back to the land use committee or whatever. So we have a motion on the floor. Would we like to amend that motion? To be more specific, Carrie?
No, I like the motion the way it was stated.
Just saying just residential uses or overnight dwelling? Well, I'm sorry, I don't remember what it was. Can somebody help me out here?
So Chair,
Yes.
from my recollection, Member Hecht, you basically essentially stated overnight residential type use. The petitioner brought up another suggestion for overnight, you said dwelling, she added dwelling in there, residential dwelling uses. So which one did you, what,
Original one.
so you wanted, the board finds that condition 8 doesn't apply to overnight residential type use. That's what
That was my motion.
that was your motion. Okay.
Okay, Ivan? I can't hear you, you're muted.
Sorry about that. I feel that we don't have jurisdiction on this. We're trying to interpret what the county wanted. So for me I feel for us to step in and clarify something that we didn't even put together is, you know, that's not our jurisdiction to make that call. So I'll be voting on no on this.
Do I have anybody else making a comment? We had a second on this? Yes?
Well, I have a comment. Oh,
Okay, go ahead, Charlene.
you know, after hearing everything and, you know, I don't feel comfortable issuing a declaratory ruling, you know, and I could see what you're trying to say, Karen, you know, where, okay, yeah, it's okay if it's only for that use that was approved at that time, I mean, you know, under that ordinance, but otherwise I feel like the council land use committee is the correct purview to get everything cleaned up or corrected or clarified or amended or whatever you call it.
Thank you, Charlene. Anybody else?
Chair Weiser, I just stand by my original objection to ruling on this.
Okay, so we have a motion on the floor, folks. And do we have a second to this motion?
Member Vial.
Yes, Chair. Member Vial, second your,
Okay.
sorry.
So,
Member Vial seconded Member Heck's motion.
all right. So the motion, could you read the motion for us again, please? I'm sorry.
Sure, Chair. So the motion that Member Hecht stated was, the board finds that condition number 8 doesn't apply to overnight residential type use.
Okay, so I think unless there's more discussion, we should vote on this motion, and then if we turn it down, then we can have another motion. So can I have a show of hands, those who are in favor of the motion? I see 3 hands. Do I
Yes.
see? Okay. Okay, so the motion does not pass. So do we have?
Chair, you would need to see the
You wanna know
opposition
who's-
as well.
Oh, okay, those opposed to the opposition? Okay, do you want me to say names? Okay,
Yes, please, Chair.
okay,
Sorry, they're gonna lock the door on me. I need to tell them.
okay. I believe Charlene had her hand up.
Yes, she did.
Okay, Charlene, Joe, Karen, and Ivan.
And Member Weiss.
No, oh, Member Weiss, did you have your hand on? I'm sorry. Yeah, okay. So those were against the motion, and we had, I'm going brain dead. Harry had,
It was Member Takashima, Member Hecht, and Member Vial that voted in affirmation of the motion.
yes,
And then it was Member Shibuya, Member Vice Chair Lay, Member Wilson, and yourself who voted in opposition. Is that correct, Chair?
and Charlene.
And Member Weiss. I apologize, Member Weiss.
Yeah, okay.
Sorry,
right.
that's correct. Yeah, I had to run out because they shut the light on me and then they're gonna lock the door.
You're operating in the dark now, huh? Okay, so Member Weiss, would you like to make a motion?
I'd make a motion that that we decline to provide judgment on this matter, or we decline. Yeah, I think that's correct. We decline to hear the matter.
Because we do not
Rule on the matter.
purview, or
Let me
what?
start again. I
Why are we
make a
declining?
motion that we decline to rule on the matter.
And the reason?
I just don't think it's the right venue. I think they take it to land use.
Okay.
There's a reason why they did it, and they need to deal with them.
Okay. All right. Do we have a second?
Second.
I'll second it. Oh,
No, Ivan seconded. Okay. So we have a motion on the floor from David Weiss that we deny the petition on the grounds that we do not feel that this is within our purview to rule on it, suggesting that perhaps they need to go back to the Land Use Commission. Do I have any discussion on this? No? Are we ready to vote? Okay. Those in favor of the motion on the floor, please raise your hand. Okay, I have Ivan, Charlene, Joe. I don't see Ross. Are you voting for or no? No, okay. David, okay. So we still do not, we have 4 people. We still do not have a majority here.
Chair, what's your vote? You would be the majority.
Yeah, I know, but I didn't vote in favor. Okay. Oh, we're kind of stymied here. I'm back to, I guess, my original thing is I would declare that this rule.
Chair, sorry. Just matter of procedure. I know that you folks did it for the last motion, but for this one, did you ask for those that were opposed?
No, I did not. Okay. Karen's opposed. Ross, you were opposed. Harry's opposed, and Deborah Bialy is opposed. Okay. I will go back to my original proposal, and that is, I think that the conditions imposed in number 8 apply to the use of that property at that specific point in time. And I would say that it needs to go back to the Land Use Commission if it is going to be expanded beyond that. So that does say, that means if they are going to expand the restriction beyond for that specific use. So another, it's a backdoor way of giving you your what you've asked for, in that I'm saying that those conditions were specific at a point in time for a specific situation. Is that?
So you know,
Did anybody have any comments on that, or?
Chair, this is Michael Hopper. You may want to just clarify for staff the wording of that, what the wording is. And I mean, if whichever side's prevailing could be asked to prepare an order, but they may need some guidance on what exactly your ruling is.
So condition number 8 in ordinance number 3494 was specific for a specific use that was granted at that time. It was not intended to apply to any future use. Does that make sense?
Chair?
Yes.
This is, so it sounds like what you're intending to say, that the hour of operation limitation only applied to the uses in effect at the time of that the zoning of that ordinance was, or the amendment to that ordinance became effective. And so that would not apply, the hours of operation would not apply to other new uses that became allowed, or are you saying?
No, that's true, but according to, now this brings up the other side of the equation, and that is, were other uses ever allowed? Okay. And that is a matter of contention that I think was not, that we've talked about today. So one side is saying that when future ordinances came and allowed TVRs, that it applied to this ordinance as well. And the county is saying, no, it did not. So, but it's not in our purview to decide that, because I think that has to go back to the Land Use Committee, because they were very specific about the fact that they did not want there to be other uses except for what they said it could be. And so if the people want to run it as a TVR, then I think they're going to have to find a way to get that permitted. Do I make sense to anybody?
I'd like to say something, Chair, if I could.
I'm sorry, Ross.
I'd like to say something if I could.
Yes, please do.
My only issue with what you just said is that at the time they were permitted to have bed and breakfasts and nursing homes. They were, because they were zone B2, and they were allowed to have all the uses of B2 except for this list in ordinance 3494. So bed and breakfasts and nursing homes were an allowed use. So those hours, they shouldn't apply to that, because that's obviously overnight type uses. So that would be my only issue with what he just kind of said.
Yeah, so my point is, and I don't know, Mr. Work, you can tell me if I'm right or wrong here, was the county's position is that those future ordinances that allowed uses as a nursing home, as a TDR or whatever, do not apply to these two pieces of property because the ordinance was specific for this property and didn't fall under general ruling. Is that my correct interpretation of this from the county?
I have had not an opportunity to discuss that with the department, so I don't know how they would come down on that question specific to nursing homes and bed and breakfast. So I don't have a good answer for you.
Chair, may I speak? Member Vial? I did ask our council work, I did ask if 3494 was now blanketed across this property, and he agreed, yes, it was, which then did include nursing homes and B&Bs.
All right, then I will withdraw my motion.
And that's why that's why I agreed with what with Harry's motion about having that condition not apply to that type of use, that type of overnight use. Because some of those types of uses were allowed when 3494 was issued.
Revisit the motion. Seems like we're kind of stymied here.
And I'll say one more thing about the applicability of what we're declaring your rulings. To me, it makes sense because they already got an NOW, even though it was dismissed because of the fires. The county is obviously going to target them for a notice of violation for this particular issue. So it's only a matter of time. And I understand what the petitioner is saying about being proactive and not waiting 2 years down the road and then another 2 years to file the appeals and to go through all that. And so I personally think that it should be in our purview to rule on this and to make a I don't even know how to say that, declaratory ruling, because I think it's just a matter of time before it will come across our desk. So.
Thank you, Ross. So Ross, would you like to make another motion?
I would make the same motion as Harry, but if anybody didn't change their mind, then I don't think that matters.
I'll second it if you want to vote on it again.
Well, Chair, generally, this is Michael Hopper. If you want to, Robert's rules sort of has something built in with that if somebody who was, who did not take that action, someone who voted against it, will make a motion to reconsider. I think you can go back and, well, actually no action, the motion was denied. So it's separate from a reconsideration because you didn't actually take any action. You denied the motion. If you want to see if anybody who voted against the motion would change their mind, you could ask that. But I don't know about making the motion again and voting on it again. I mean, you can try because technically there wasn't an action taken to pass anything. So I don't think you would need to go through the formality of a reconsideration. But you're correct that you would want somebody who voted against that motion to change their mind potentially, or come up with some other motion. But at this point, you would need 5 votes either way, of course.
And you're muted.
Is that Chelsea who's been recording this information? Do we know how many people who voted for Harry's motion?
Yes,
and who
Chair.
did not?
We do
Okay.
have that. So as far as Harry's motion, we had, what do we have for Harry's motion? So for Harry's initial motion, it was member Takashima Member Vial, Member Hecht, that was in agreement, and aye. And opposition was Member Shibuya, yourself, Member Wilson, Vice Chair Lay, and Member Weiss.
So we had 3 in favor of it. Was there a 4th in favor of it?
Oh,
I
Chair,
have
it was 3 to 5.
Yeah, 3 to 5, okay. So we would need 2 people to change their mind.
Chair, may I speak? This is Member Vial.
Sure, please.
So I think going back to Harry's original point that we're getting lost in the weeds of this because the bottom line is it's zone B2. The zoning there has been since 1986 it got moved to B2. So it moved with all the other B2 stuff where it allowed nursing homes and it allowed B&Bs. And so then when the county said change that verbiage from B&B from N to TVR, that was just because the county was changing their language of how they spoke about this. So I'm not really certain. To me, I feel like those people are getting hung up by this point of the hours of operation, which I totally get because I've seen that happen before and I'm like, ooh, hours of operation. But it's not meant for nursing homes. It's not meant for B&Bs. So how can it be meant for a TV&R? How can that be the hanging point is hours of operation? It doesn't make any sense to me. It seems it's oppositional to what the law was intended to try to clarify. They were
Hi, Member Vial, Chair. Sorry to interrupt. Member Hecht stepped out for a moment, so I don't know if you guys want to pause for a little bit to wait for him to return so he can vote on whatever it is or help or participate in deliberation with you folks. He's just not present at the moment. He might have needed a bio break.
Does anybody else want to take a 5-minute break? No? Yes?
Yes. Alrighty.
5-minute break, so we'll come back at 5:08.
Yeah, I gotta check that I'm not locked out of the building now.
Harry's back.
Can we just round that to 5:10?
Well, he's here, he's back.
Okay.
Oh,
Let's continue.
Yeah, I'm getting a little nervous.
Well, okay. I would like to see if we can wrap this up, folks. So,
Chair, I think you might have, do we have everybody?
uh,
I think Vice Chair Lay might have left because you did
Oh, yeah.
basically say recess till 5:08.
Okay.
And Charlene's member Shibuya stated she needed to check to make sure she could still access in and out of the building.
She's still there in the dark.
Yeah. Of course, I don't have a key, so if they lock me, somehow somebody locks me in, then I won't be able to get out.
Oh, no.
Good. Yeah, let me just quickly run since you guys are on break, right?
Okay, why doesn't everybody else, unless you have to go somewhere, stick around and then when the others return, we need to wrap this up, guys.
Question, what are we doing?
So when you stepped out,
Yeah.
yeah, what happens is you lose your, you should like say that you need to step out and then pause.
Oh,
Because
okay.
the meeting can't really go on without you.
Oh, okay. Sorry.
Because then you wouldn't be able to vote.
Yeah.
Wouldn't get the whole stuff kind of. So what happened was when you went out, you paused it, and then chair sort of said, okay, 5-minute break, and then people left.
Oh.
Yeah, so that we're waiting for them to come back. And then Charlene is kind of like trying to figure out if she's locked in at the county building.
Ah.
I don't think it's fantastic. I know. You know what I mean? I've never me either.
And I never found like this, but just and it does kick it on. She's such a moving from June. So she, yeah, she's very confident. I think she's I'm sure you got it.
That's not right.
From, yes, and then so it looks. Yeah, and then she's actually, so I think. It's in this. Like, she only do the group great to look at it and go. Like, yeah.
Thanks.
She got her lights back on.
Yeah, I figured out how to, somebody was still here, so I told them, I don't want them to lock me in from outside.
Glad to hear you won't be spending the night there.
Oh, Ross. Yeah. Oh, Mary's is really good. Yeah. Be good. I forgot that they were. Yeah. Doing it, you just, just so through the heavy lots. Yeah, to make sure that. That's just not. Is this the first time you've experienced? Oh, us personally, but it's been a. That's what I'm about to actually. You asked the mayor's office. No, that was the. Also, the like maybe last one. I went to look in helps with that organization that they've had charter black cleansing and then they got yes, it's big. Like was that was very popular. That was such a natural question. Chief of Julie changed well, comes you have to change locations and this. Yeah. So, but this one was, they had all their activate their ranks. And they couldn't even figure it out. They had some. Like they. I thought you were too forward.
Michael? Are you still here?
Me? Michael Hopper?
Yeah. Can I ask you a question while we're thinking? I'm thinking about doing something, if I use the words permitted.
Hey, this is, we should probably have this discussion.
This
on the
meeting
record
is being recorded and
if
summarized.
we go back, if we're not ready, or you could give me a call and we could discuss separate if you want, the direct legal advice. But if we're going to do it, we should make sure we're back on record.
Yeah.
No. Oh. Oh, I saw that.
All right. Let's see, I don't see Deborah. Deborah, are you around? Aha, good, Deborah. Everybody back? Right, Charlene? Charlene, are you back? Oh my God, Charlene, come. Dave I see Harry. Is David Weiss there?
Yeah.
Okay, I see you there. Okay. So now we're just waiting for Charlene. Gosh. Charlene. Can we continue without Charlene being here, or do we have to wait for Charlene coming back because we have quorum? Hmm?
just one less.
Do we know if Charlene is coming back? Chelsea?
Hi, Chair.
Yeah, can you call Charlene and just make sure she's coming back?
She didn't indicate that she wasn't coming back, and I believe she came back, but it's just frozen. I can try and reach her on her cell.
Okay, thank you.
Sorry. Want to come down to the Republic? Okay. Okay, okay, thank you.
Hi, Chair. So we managed to connect with member Shibuya. She's going to come physically to the conference room. She just needs to close up shop and then come down this way. So probably I would give her at least like 10, maybe minutes. Well, you know, I will.
I'm getting caught time-wise. I'm gonna have to leave soon. What business do we have left to do? Is that, we voting again?
Karen, you're muted.
Thank you. I said, I mean, this has gone on way too long. Is there any way that we can just continue without member Shibuya? Can't even talk anymore. Without Charlene?
Well, Chair, this is Michael Hopper. If you
Yeah.
intend to vote, she would not be allowed to vote
Well, that's fine.
later on potentially, but you could continue. The potential issue would be if this is at some point viewed as a contested case, which I know the parties have had sort of various positions on that. If she did not examine all of the evidence before voting, she might not be able to vote. So if she comes back, she might not be able to vote. Potentially, I guess both parties could waive any because it's not evidentiary examination, but that would be the risk. So if you want to continue, that's fine. You may be down a member. If you can't vote at this meeting, at the next meeting, you could have her review the transcript and still vote. So if you want to continue now and see if you can vote on something, you can, but there may be an issue once member Shibuya comes in. So that's the only concern.
Yeah, well, it seems to me we are, getting late for everybody concerned here. Can I just have a show of hands? How
Wait,
many of you-
Chair, 1 sec. Member Shibuya is here.
Oh, good.
Present.
Oh, thank God. Okay. Yeah. Welcome back, Charlene.
Hi.
Okay. To make a motion. Okay. I would like to make a motion that the intent of condition 8 in ordinance 3494, limiting permitted hours of operation, does not apply to permitted residential use.
That's okay. Oh,
I second that motion, member Vial.
Okay. Anybody else want to comment on that? We have a motion on the floor.
I support it.
I'm in agreement. Sounds good, Ivan.
Anybody else want to talk? Joe?
Wait 1 second, Chair. Just make sure that I
Oh,
have the
I'm mute.
motion correct. So
No,
you
I think,
said the
sorry.
intent of condition, oh, sorry, the intent of condition 8 of the ordinance 3949 for limited hours of operation does not apply to permitted residential use?
Right,
I just want to make sure I wrote this down right.
right.
Chair, the petitioners want to clarify something.
Ordinance 3494.
3494. My apologies. Dyslexia.
I thought maybe that was my mistake. Okay.
Sorry, Chair.
Any further discussion on this? Are the members ready to vote?
Yes.
Okay. All those in favor, raise your hand.
Aye.
One. Aye. I see
Let's
David.
just make sure we got everybody. So verbally, Member Hecht, Chair Green, Member Takashima, Member Vial, Member Wilson, Member Lay, and
Say, well, okay.
Somebody's
Don't worry about it. Mr. Peter, stop.
no, somebody's talking.
Need
Okay.
to speak a little better.
yes,
I'm
Member
sorry.
Wilson. So I will repeat.
Please.
It was Chair Green, Vice Chair Lay, Member Takashima, Member Vial, Member Wilson, all voted aye for the motion, and Member Hecht. And then for no to the motion, we have Member Weiss and we have Member Shibuya.
Okay.
Is that
right.
total, everybody?
Okay. I think that's it, huh?
And then
Unless-
Chair, would you
Yes.
have the petitioner prepare the decision in order for your consideration and circulate it to Mr. Work prior to, I guess, filing, so that we would have a decision in order to act on?
That would be wonderful. Ms. Paris, you agree to do that?
Yes, Chair, thank you.
Okay. All right. I want to thank everybody for your patience and your input here. This was a really difficult case on a number of different levels, and I appreciate the fact that we were able to conclude it today. I think that this concludes our meeting and we are done for the year. Our next meeting is on January 9th, 2025. So I'd like to take this opportunity to wish everybody a very Merry Christmas and all the best.
Steve Melikaliki Maka, right?
Okay.
Safe and happy one, everyone.
Yeah.